you completed? Yes. What's your vote? Right? Not yet completed. Not yet completed. Right? Now tell me why we should not bring the CBI up there. It's a very serious allegation, Mr. Joe. Weather permits. Weather was fantastic in the month of February when I passed. PMGSY was okay, but you see, Mr. Joe, you were not entitled to any benefit of the PMGSY in your case because that was not a part of it. Whether the PMGSY land it was made a PMGSY, although the other two were the state projects. And in those state projects, you have taken the entire money. No, not entire money. Yes, this is what has been stated. I have categorically mentioned in my. You receive every money after deduction. What's I don't think we are sending more money to this. Issues are on the spot as Mr. Joe must have said that within 8 days I'm going to complete it, taking into account the forecast where it says the next 7 days it is going to rain. Yes, government, what is the status? Why you have not been able to pursue them to do the work? On the verge of completion. No, there is no verge of completion. It was in the verge of completion in 2014 when you took the entire money. No. That will take a decade. This is the case of a decade. 10 years have gone by. We filed this PIL in 2020. The PIL has been filed in the year 2020. Order was not issued. You have got your completion certificate prior to that event. Yes. Because this is a serious case. Last time I gave out that taking into account that Mr. Joe had monopathy submitted, they let me complete it within 3 months. But then, if it is not being done, I think why should we not employ the criminal proceedings against them? Because this is the case where he has already taken the money. There is a completion certificate which has been given. That was given in the year 2015-16, which was given. Till now, nothing has been done in respect to those works. And it is again the 8 days out there. How is it possible? I think it's a fit case for employing the CBI into this case because the state may not do it. So the CBI. We the specific on the last occasion, the specific argument made by Mr. Joe was, just look here. I still have time to complete it by March 2024. So another 2 months here or there doesn't make any difference. So we said that okay. That was his assurance. I thought by way of an affidavit we take it on the next month. Or right, just right. What is the status out there, then we may consider passing it to notice. It is not done. We believe that the things that have been done in the meantime, we have called for the opening. Did I say that?
Yes.
No. Friday. Friday you file it, you take it up, you file it. We will look into it, Mr. Joe. This is not done. One, I was very lenient enough for the last occasion. I was expecting the battles that have been done in the meantime. I would have just closed it, having done the entire work, nothing further remains.
Also, and also be
In
permitted,
the same state of affairs.
and also be permitted to file an additional affidavit placing on record some pictures also of the present condition.
Yeah, bring it. If I have it on Friday,
Okay.
that ask anybody else to be there. But we have to video conferencing. Mr. Joe, right? I want to see, I'm not concerned, as you have categorically stated that you have not done your work, completed the work. We now put it on the screen as to why further actions are being taken. Whatever amount is to be recovered, and then record it along with the liquidated damages. Have that provision as the contract saying that there's a liquidated damage, all this while, and the sufferings which the people have. Everything. If it are big contractors,
Now, two factory investment of the construction of what electoral people 96.4%. That is as on
give us the completion
as
by
first
give us the completion by right
and next is one of the
as we speak, Mr. Joe, as we speak, we must be working. Let's have it. Let's have it on Friday. You file your affidavit. Friday. Right? Monday, we'll see what consequences because of the possible. Friday, we take it up. As to whether on that day we can pass it. We are concerned about the state of things. You see, whatever illegalities have been done. We are not on that. We wanted the thing to be done. And that is why on the last occasion, irrespective of holding many other things, we said, okay, let them do the work. Because completion of the work is in the public interest. Doing anything against these will not suffice. So we were of the opinion, and that is why whatever he asked, I never said that okay, I wanted to deal with him and say that okay, no, you complete it by month. I asked him how much time does he require. He said by May. Because reach the matter again on Friday, on which date the AAG, Mr. Swenson, appearing on behalf of the state, shall file an affidavit with regards to the progress of the work in which Mr. Swenson, the council, appearing on behalf of the petitioner, shall also is also given the liberty to file petitional affidavit giving to the notice of this court as regards the present status of the work.
Keep development.
Yes, Your Lordship. Lord, I may be allowed to make an mention for the unlisted motion. Analogous matter with item number 1 and 2 for non-inclusion of name in the electoral roll for the upcoming ULB elections, Your Lordship.
Yes, ma'am. Maybe possible.
Yeah, please, Your Lordship. I take to mention item 7 on behalf of my senior. I'll grant 2 weeks' time to file affidavit in the
For motion, item numbers 1 and 2.
Here, what is this case?
Your Lordship, this is to do with the non-inclusion of names in the electoral roll for the ULB elections. Hello?
Yes. Your name was there, Mr. Vishnu.
Name was there in the assembly constituency elections.
No, no, no.
The
Your
electoral.
name in the voters list was there earlier.
Yes, Your Lordship. If we go by section 34 of the rules, my lord, the names are to be transferred from the electoral list of the constituency into this ULB electoral roll, the urban local bodies election. This is Nagaland Municipal Act 2023.
No, see, as I find.
Hello.
Now, this is the road.
Madam.
So you were already there earlier.
Not in the ULB list. Yes, Your Lordship. Earlier, yes, under the constituency electoral roll, yes.
Where is it?
That is part of the petition, Your Lordship.
Where is it?
Annexure A, my lord. Page 17, my lord.
Item number 83.
Serial number 83.
And how many? One.
Yes, one petitioner in this item number 1. In item number 2, the other petitioner, Your Lordship.
86.
88, WPC number 88. That's serial number 672.
It's okay. Now, 83, your father's name is Noshi.
Nihoshe.
And 86, 83, 86, father's name is same.
No, different, Your Lordship.
86, 86, number 86. And we come to page 17.
17. So Same name, but different people, different persons.
No, it's the same, house number same. House number
Oh,
100.
my apologies, Your Lordship.
No?
Yes,
So, is 86 name is there in the electoral rules of the US?
that I do not know, Your Lordship.
Because that is relevant. Why they have excluded this name?
Your Lordship.
Yes, now thereafter, the preparation of the electoral rules for the constituency, Swansea municipality, with regard to Swansea. You gave your names.
Yes, Your Lordship.
Yes, you see, therefore, the names are, whose names are there? 86. What is it? 84, 88. Heto. Heto's name is where? In page number 18.
Serial number 5. N Heto
yeah.
Yeptuni.
Therefore, you see, all these are together.
Yes, my lord.
It is apparent, therefore, all
No,
are
no.
of the same family. See? That is why it has been given together.
No, Your Lordship. This is a form where several names have been included, Your Lordship.
No, this is for the purpose of giving it name and particulars of alternate residing in the above area. Then what happened? Electoral round number. And page 19 is what?
Lordship, page 19 is their passports,
120.
photographs, passport photographs.
120. So your name now does not feature in which row?
The latest roll, Your Lordship.
Where?
It's not an ex, Your Lordship, because the name is not there.
How do you know?
Your Lordship will kindly appreciate the representation that I have given and the letter, the forwarding letter. Page number 33, Annexure 4. This is the forwarding of complaint.
But this is what has been provided by the additional deputy commissioner.
Yes, Your Lordship, and also the returning officer for the
So
Elections.
pursuant thereto, they have not taken any action. That is why you are approaching this court.
Yes, Your Lordship. And after we have approached this Honorable Court, we got the information the other day that the representation has been rejected on the ground that the Rule 14(1)A, according to Rule 14(1)A, the window period that has been opened to them to make a complaint for inclusion that has already expired. Now, my lord, will kindly appreciate this peculiar circumstance here. Your Lordship, under Rule 6, the state is to publish the draft roll.
When is the elections?
Your Lordship, elections is,
Has the notification been issued?
yes, Your Lordship.
Then how do you take care of that?
No, Your Lordship. The Rule 37 allows that the inclusion of name can be done till the time of the completion of the filing of nomination. The filing of nomination is 7 to 11.
Where is the rules?
Your Lordship, it is at page 31, annex at page 31, Your Lordship. Annexure F, starting from page 30,
No, no, this is okay. Where are the rules?
the rules. I'm giving Your Lordship a copy of the act as well as the rules. If I may be allowed to take Your Lordship to Rule 6.
Now, as per the rules, who provide, how are the electoral rules made?
That's why, Your Lordship, kindly to Rule 6.
Rule of the disqualification of a person who is not.
Your Lordship, until and unless the draft roll is published, how will the public know, a voter know that his or her name is not included, Your Lordship? In this case, the draft roll was never published. So the intending candidates were not aware that their names are not included in the electoral list, Your Lordship. May I also take Your Lordship to section 37 of the Act?
When were the draft rules published?
Draft list was never published, Your Lordship.
When was it published?
4th March 2024.
14th?
March. You also I am supplying
No, that is a notification, Your Lordship.
When was it published?
4th March 2024.
4th March.
That is for draft publication of electoral
Draft rules published.
Draft list, draft roll.
And on that day, his name was there? No.
Your Worship here, just to cut the time. Your Worship here, in WBC 87, 88, and 90, rules, they have submitted their name for inclusion in the electoral roll in the month of August, September later, 2022. So it was under all Act, Municipal Act 2001. Then after that, the election, municipal election was supposed to be held in the month of May 2023. But because of certain difficulties, election was cancelled and the act, all act was repealed. Now, the notification is started from Nagaland Municipal Act 2023. So the petitioner has, they have filed the earlier one, repealed and cancelled election, they have applied. And thereafter, since the election was cancelled and the relevant law also repealed, so is the one better spending in the before the honorable Supreme Court. So because of the Supreme Court direction, again, the new Municipal Act 2023 was enacted, and as per that provision, the notification has been issued by 4th March 2024. So, Your Worship, here, those petitioner in WBC 87, 89, they have applied in the repealed and cancelled election. And thereafter, since election
No,
was cancelled.
but did you inform them that the earlier rules have been kindly apply it properly?
Yes, it is already notified. Cancellation
No,
of the
kindly
election.
see this. Kindly see the rules.
Your Lordship, I have submitted the documents.
Kindly see here. Rule 5(6) of the new rules. 5(5). For the purpose of preparation of the roll, the electoral register may send letters of request in Form 1 to the occupants of the dwelling houses in the constituencies or any part thereof, and every person receiving such letter shall furnish the information called for therein to the best of their ability. Did you do that?
Yes.
You did? How will they know about the 2022 rules or 2023 rules? They may not know that. You have come up with that. Okay. If you would have come up with a particular procedure, new procedure out there, then follow it. How will they know?
So, Your Worship, at the petition March 4th March 2024, draft election electoral.
Did you publish the draft rules?
Yes.
Show me the draft rules. The notification by which you have published. As soon as the roll for a constituency is ready, but not later than the date given in the program notified by the commission, the electoral receiver shall publish it as a draft together with a notice in form intimating the date by which claims or objections. Did you do that?
Yeah, we have just by the way, we invited.
Now, did you do as per 6(1), rule 6(1)?
No,
Yes, here. Page 23, kindly come to this. 4th of March, you say, whereas in order to general election to the municipals of the 39 councils with a view to accommodate in the road so and so, whereas the government of so and so, I so and so, the state election were in exercise of the powers conferred under so and so. Hereby direct the special summary revision of the electoral rules for the so and so. Draft publication on 8th of March. You say that on 4th of March it has happened.
or 40 notification draft.
When did you have the draft publication of the electoral rules?
Your Lordship, the question is also, where was it published?
No, whether it has been at all published
My Lord.
on 8th of March.
Yes, I think it's already published, but Your Lordship, I have to take instruction.
Tomorrow.
No, Your Lordship, tickets are to be given out tomorrow and day after tomorrow.
Tomorrow is only 4th.
Yes.
Tickets,
Huh?
there is a problem with the tickets also. These are intending candidates, Your Lordship. In fact,
No.
many voters have been left out.
No. The period for filing nomination is on 7th.
7.
My Lord, that is there, but tickets are to be given out tomorrow and day after tomorrow. Can we take it up at a lunchtime, Your Lordship, 2 p.m., if my Lord may kindly allow?
I may allow, but whether you will be able to get it.
Office
So
is
when
here in
was the
Kohima, Your
draft
Lordship.
Publication made
Yes, after lunch.
after lunch.
My Lord.
Just get that information. One. And secondly, you have to show me that there has been a compliance to Rule 6.
Yes.
Because you see, there is one judgment of Indrajit Borua, Supreme Court, that once the publication rules have been published and the election process have already started, you cannot touch it. But the fact remains, however, then if you have not done the drafts, where he specifically alleges that the draft have not been published.
My lord.
So under such circumstances too, the entire thing will go. You may have to stay the entire elections. But this is not one, it has far-reaching consequences on everybody.
My lord.
Take it away too.
Your lordship, item number 38 and the unlisted motion which I mentioned may also be clubbed together.
What?
Item number 38 is also to be taken up along with item number 1 and 2
Okay.
in the supply list. Oblige, your lordship.
For motion, item number 39.
Yes, madam.
Your Lordship, my case is about regularization of my husband's service and pension benefits.
Issue notice.
Yes, Your Lordship.
Issue notice returnable by when? When can you file your affidavit? How much time?
It will take time.
Give me a good date. When can you file your affidavit?
After 4 weeks, Your Lordship, we'll make an attempt.
Issue notice making it returnable on 26th of June. 26th of June. 25th of June. 25th of June. You appear for everybody? Accountant General is
No, Your
different.
Lordship, I'm for respondent 1 to 8.
1 to 8.
Yes, Your Lordship.
9?
No,
9 is who? Who appears for the Accountant General? There was a council, no? Who appears? We appear. Yes. So and so appears on behalf of the respondent numbers 1 to 8, and Mr. Joshua appears on behalf of the respondent number 9. Steps be taken by way of taking into account the above. No. Extra copies of the petition be served upon them by tomorrow.
okay, Your Lordship.
By tomorrow. On the next date, returnable date, the respondents shall file their affidavits. No, before the next returnable date.
For admission, item number 3.
Lordship, I have received the state's affidavit on 19th of March, Lordship. I may be given 3 weeks time to reply to it, Lordship.
What affidavit in reply not filed?
Yes, Lordship.
You
I want to file a joint affidavit in reply for both the private, for all the respondents, Lordship. The state as well as the union.
This matter has been pending for so many things have been filed in the meantime.
Lordship. I'll be filing positively, Lordship, by the next date.
What is your case?
The army, Lordship. They have encroached my land.
Stop from evicting the land. Possession from their land. What is your case?
And it seems the state respondents, Lordship, they have issued title documents to the petitioners, to the 2 petitioners, Lordship. Their stand is not clear. This is
No, what is
creating
the-
the confusion,
Why
Lordship.
are you aggrieved?
I am aggrieved because, Lordship, the army, Lordship, they are trying to dispossess me out of my lawful possession of my property, Lordship.
Your property.
Yes, Lordship. The deputy commissioner, that is he has issued pata to me as well, Lordship.
What is their stand? Their stand must be as regards, these are patta numbers.
Yes, Lordship. I'm a pata holder, Lordship.
And what is their stand?
They don't have pata, Lordship. And
They would not. The government does not have a patta.
Yes,
Patta
Lordship.
means a lease.
yes,
How can
Lordship.
a government lease
Yes,
itself to
Lordship,
itself? What is
But
their stand?
they have admitted in their affidavit that there is absence of clear demarcation of the defense land. In paragraph 2, Roman 1, Lordship, at page 2, Lordship. I wish to make a reply to the affidavit in
This
opposition.
affidavit, you have not filed the affidavit in reply to the 27th July 2022 affidavit filed by the union.
Lordship, I wish to file a comprehensive affidavit. I was waiting for the affidavit to be filed by the state respondents, which they have filed only on March 2024, Lordship.
Where is the affidavit?
It is under drafting, Lordship.
Let us see the affidavit, what would they say? Mr. Imsong, here is a case where you say that pursuant to the affidavit representation received,
Yes,
you took steps for spot verification,
yes,
but that has not happened.
not yet received. So
Why?
Have to take
It is,
instruction,
it is
otherwise,
under, it is under you.
yes, yes.
Why you are
Under-
not doing it?
Under 70, we have endorsed the district
We fixed the matter again on 27th of June. While you
27.
are- In the meantime, the district land and record survey officer is directed to make the spot verification and submit the report before this court.
My lord, my lord.
You may file the affidavit.
My lord.
I think that is a better, it will somewhere proceed. Because he filed a representation in 2022 and today we are in 2024.
My lord.
Full stop. Mr. The instant writ petition has been filed by the petitioner. Stating it being aggrieved by the action of the respondent number 3 in trying to forcefully take over the possession of the petitioner, evict the petitioner from the petitioner's land. It is the specific case of the petitioner that the petitioner is the owner of the land and have been issued a patta.
My lord.
Full stop. It is also seen that the petitioner had submitted a representation before the deputy commissioner, Dimapur, on 13/5/2022. Today, while perusing the affidavit in opposition filed by the respondent number 1 and 2, it is seen that the deputy commissioner, who is the deponent, had stated in paragraph number 8 of the said affidavit that pursuant to receipt of the representation on 13/5/2022, a request for spot verification of the land was sent to the district land record and survey officer, bracket DLRSO, bracket closed. However, the district land record and survey officer have not taken any steps in that regard. Full stop. Taking into account this court have also perused the affidavit filed by the respondent number 3, wherein it has been the categorical stand of the respondent number 3 that the petitioner is in occupation of the land of the respondent number 3. Full stop. Under such circumstances, a spot verification is very essential for the purpose for a just adjudication of the instant proceedings. This court therefore fixes the matter again on 27th of June 2024. In the meantime, the district land and record officer, land DLR
Land
Records and Survey Officer, Government of Nagaland, is directed to carry out the spot verification and submit a report before this court, which has to be on the basis of an affidavit. Full stop. The respondent number 2 is also directed to ensure that the district under whom it is, the DLRSO is under, I think he will be under the Deputy Commissioner, shall also ensure that the DLRSO shall take appropriate steps upon receipt of the appropriate steps and do the needful. Full stop. Mr. Imsong, the learned additional advocate general, appearing on behalf of the state of respondent number 1 and 2 submits that the same shall be duly intimated to the officials for doing the needful. List the matter accordingly.
Let the interim continue.
What in
Interim.
the meantime, the petitioner would be at liberty to file their reply to the affidavit
My lord.
oppositions filed by the respondent number 2 and 3. The interim order passed earlier. Where is that interim order? There is no interim order.
There is interim lordship. Interim was granted,
Interim finished on
was initially granted on 25th of May 2022 lordship.
after 2022. There is no interim order. What do you say, Mr. Yangwati? There is no interim order there. Interim order passed earlier. Shall continue till the next date of listing.
Deeply obliged.
For admission, item number 4.
May I please, Your Lordship?
Hmm.
My Lord, here I am appearing for respondent number 4, and I just received the reply filed by the petitioner. Therefore, I pray for some time to seek some clarification.
For what?
Some clarification has to be sought from the.
What is the case
office.
of the petitioner?
Your Lordship, the petitioner is bring for rectification of the, for the fixation of scale, Lordship.
Consider petitioner's forwarding letter dated for review of the pension case. Is it? Is that the only relief you are asking for?
Yes, Lordship.
Why I read in the nature area should not have to direct the respondents to consider the petitioner's forwarding letter dated here for review of the pension case by making correct equivalent scale of so and so besides so and so. In the within the survey. So this is his final relief he is asking for.
No,
Why
Your
you are not
Lordship.
considering?
But in the affidavit in reply, which we have received this morning, they have brought up their own calculation of how much should be the basic pay, the grade pay. For this, I need to get some instruction from the AG.
Understood, but what is his final relief? See,
Your Lordship,
what is he asking, Mr. Joshua? See the prayer. Page 10.
Your Lordship. Review of pension case of the pensioner case, by making correct and equivalent scale of pay to that of the assistant director. My lord,
What is he asking? Now he is asking that this court should direct you to consider his review.
Your Lordship, as far as our affidavit in opposition is concerned, the scale pay that he is receiving is the correct pay scale. No correction is required, Lordship. So if a
So
direction
therefore,
is.
they have already decided that.
Yes,
Then
Your
how
Lordship.
can Mr. Counsel tell me, if they have already decided that this is the correct scale of pay,
No,
are you not therefore required to amend your prayer
no,
that you are entitled to this?
yes, Lordship, in my reply, I have already
No,
stated that.
no, by way of reply. This is the final relief. Can by way of a reply, you ask for something else?
Your Lordship, this
You
morning,
amend your petition and say that, yes, in view of their stand which has been now taken,
yes,
or file some miscellaneous application saying that in view of the same stand which they have now, this has already become infructuous. So you are required to now say that you are entitled to this. What you are asking, kindly consider, send this particular document to so and so, ask them to consider. They have in the meantime considered and said that look here, he is not entitled to more than this. We have already given him. Then does it make any sense for this court to again ask them to consider? They've already made a decision. So under such circumstances, you are to come up before this court and say, look here, I am entitled to this. How do you take care of that? Not by way of a reply. You'll have a lot of trouble. And one more relief, that taking into account what he has stated in the affidavit. So under such circumstances, I'm entitled to this, and as such, his affidavit is wrong. Do something. Otherwise, you don't have a case. Your case has become infructuous. What?
Lordship, let this matter become of the 2 weeks, Lordship. After 2 weeks, Lordship.
Or you do one thing. In view of the stand, you file another fresh petition. You need to do that. Without that, you cannot. Kindly see what is your case. Kindly see page 22A. I'm trying to help you out. Otherwise, you are in more trouble. See page 22A of your petition.
Lordship,
Therefore, as requested by the retired official, your office may kindly review his pension matters. So under such circumstances, you are that as they are not reviewing, kindly ask them to review. They have already reviewed and say, look here, you are not entitled to. So don't you think that you are required now? And I am concerned about the person
Yes,
concerned
yes.
because as a most, he is a pensioner.
Yes,
He
yes.
has retired. If you delay this thing, which is going to happen, at the end of the day, you are not going to get any relief in this petition. You will be in more. That think about his. He may not see his pension being increased during his lifetime. Anyways, we are in a polluted world.
Yes.
What do you want?
Lordship, since this matter is handled by my senior, can they allow 2 weeks time so that I'll consult with the senior
Okay,
Lordship?
the counsel appearing on behalf of the petitioner submits an This court have duly perused the writ petition. And from the contents of the said writ petition, it appears that the petitioner has sought for a relief that to the effect that the review petitions which have been submitted should be directed to be considered. In the meantime, pursuant to filing of the instant writ petition, who is that? Who is appearing? Who has filed that affidavit?
Respondent number 4, Accountant General.
The respondent number?
4.
The respondent number 4 have filed an application wherein it has been categorically mentioned that the petitioner is not entitled to the revision in as much as the petitioner has been granted the correct scale. For taking into account the above, the learned counsel appearing on behalf of the petitioner seeks for 2 weeks' time for instructions as to what further steps the petitioner requires to take in view of the said stand. This is the matter after 2 weeks.
For admission, item number 5.
Okay, this is your lordship.
Yes, what is this?
Your lordship, here I have already sent a affidavit for waiting. So this
Mr.
letter,
I am Song, the learned petitioner general submits that pursuant to the filing of the amended written petition. The draft affidavit has already been sent for vetting, and as such, some more time is required for filing
Monday,
the same.
next Monday.
He submits that most likely the affidavit can be filed by 10th of June. Taking into account the above, list the matter again on 13th of June. In the meantime, the affidavit will be filed.
There's an interim.
There is an interim.
What?
There is an interim.
13?
Interim.
Interim order, yes. The interim order past the year should continue. till then.
For admission, item number 6.
Lordship. Lordship, I just received the affidavit in reply filed by the petitioner Lordship.
Hmm?
So affidavit in reply Lordship filed by the petitioner Lordship. So kindly grant me some time to go through the same Lordship.
For what? Rejoinder not filed.
Lordship, I filed my
Need to
reply
file.
Just today,
just
Lordship.
this morning. This morning, I filed my reply this morning.
You have filed
Yes, Lordship.
today.
Yes, Lordship, this morning.
Mr. So-and-so, the learned counsel appearing on behalf of the petitioner submits that the affidavit in reply has already been filed today. The same, however, is not on record. The registry shall bring on record the same affidavit in reply. Is it on record? You filed it today only.
Yes, Lordship.
Oh, these matters, regularization.
Yes, Lordship.
This is the matter. When? Next week?
2 weeks, Lordship.
This is the matter after 2 weeks. Why you want 2 weeks? This is the matter on next Monday.
Obliged,
The
Lordship.
registry shall bring on record the said affidavit.
For admission, item number 7.
May I please, your Lordship. Lordship, here we're yet to file our affidavit, your Lordship. If 1 week time be given, your Lordship.
Reply not filed.
Yes, your Lordship. Today,
We have not filed reply on March, April, and May also.
Lordship. If 1 week time be given, your Lordship,
We have
next
an
week.
interim.
No, your Lordship.
What is your matter about?
Lordship is regarding to regularization of his work charge service, your Lordship.
How are you how can you be regular?
Lordship, as per the 2004, your Lordship, seniority come made basis, your Lordship.
2004 is going for a 6 week 2015. Now tell me how,
Lordship, both the OMs are in operation, your Lordship.
how are you to be regularized? You are a carpenter come helper.
Yes, your Lordship.
What charge?
Work charge, your Lordship, carpenter. Your Lordship.
Then
Lordship is,
have you completed 30 years?
no, your Lordship.
Then how do you bring?
Lordship, as per the information furnished by the department, your Lordship, there was regular appointments, your Lordship. A number of regular appointments have been made, your Lordship. Lordship, as per the 2004 and 2015 OIM, your Lordship.
2004 is there, but 2004 has gone to 2015.
No, your Lordship, if I'm correct, your Lordship, both the OMs are in operation, your Lordship.
She can't help you.
Lordship,
You submit.
your Lordship, both the OMs are in operation, your Lordship. Lordship, as per the 2004 and 2015 OIM, your Lordship, 50% of reservation was to be done for the work charge employees, your Lordship. Lordship, as per the information furnished by the department, your Lordship, ample number of regular appointments have been done, your Lordship.
Understood, but whatever may be,
Lordship.
you can only as per the 2015 after you complete 30 years.
Lordship, no, your Lordship, it's seniority come merit basis is also in operation, your Lordship.
There's no seniority merit. Let us see the 2015.
2004, your Lordship, 2004,
Or let us first see 2015.
your Lordship.
What do you say about number 1? 2015 page 18.
Lordship, as
All
per,
existing work charge and casual employees of various who are enjoying scale of pay and who have completed 30 years or
Lordship.
more continuous service as on so and so will be regularized by conversion of their post into regular ones.
yes, your Lordship.
Then, how do you take care of that? You are a work charge.
Yes, your Lordship.
Then,
Lordship, regularization is to be done as per the 2004 and 2015, your Lordship. If the employees have not reached 2015, as 30 years as per the 2015 OIM, your Lordship, it's the 2004 OM is to be taken in operation, your lordship. Taking into account the seniority cum merit basis of the employee, your lordship.
What do they say in the affidavit?
Lordship, they are
They
saying
say
that,
you have not qualified.
lordship, they are saying,
Prove that yourself. 30 years have not been done. Yes, correct?
yes, your lordship, 30 years have not been completed, your
No.
lordship. I'm not denying that one, your
There
lordship.
was a challenge made to this 2015 office memorandum saying that this was there, and there was a judgment being passed by the
Lordship.
single bench, and then there is a division bench where judgment said that nothing doing. 2015 shall they duly take care of. Insofar as it is not inconsistent, 2004 will remain insofar it is not inconsistent with 2015. That's the judgment of a division bench.
Lordship, if, like, your lordship, if the matter can come up, pass over the matter, your lordship, there is some matter, your lordship.
Timing?
Time being, your lordship, there's some matter,
For the timing?
yes, your lordship. If
They
the
are
matter
doing
can
it.
come up on tomorrow, your lordship,
But
there's some recent judgment, your lordship, where the, as per the 2004 order, your lordship, the petitioner have been regularized, your lordship. If I may be allowed to
Recent
produce
judgment?
this, yes, your lordship, just last month, your lordship,
Last month,
yes, your lordship, passed by this honorable court, your lordship.
division bench.
No, your lordship, single bench, your lordship.
The division bench is there, na? I can't help you.
Your lordship, even under 2004 also, he's not eligible because he's not the senior most, your lordship.
Hmm?
Even then, even if you go by 2004 OM also, he's not eligible, your lordship. He's not the senior most. So on two grounds, he's not eligible, your lordship.
No, 2015, 15, you have to qualify. You don't have the 30 years.
Lordship, if the matter can be passed over, your lordship, for tomorrow, your lordship. Pass over for the day, your lordship.
Chalo. At the request of the learned counsel for a petitioner, matter be listed again tomorrow.
Lordship. Much obliged.
For admission, item number 8.
With this, my
Yes.
lordship, I received the affidavit in opposition of the respondent government just now. So
Just now.
allow me 2 weeks to file affidavit in reply to the affidavit in opposition.
Ms. Judge Jimomi, the learned counsel appearing on behalf of the petitioner submits that the affidavit filed by the state have been received by her during the course of the day. And as such submits that she would like to file a reply to the same. This is the matter again on 25th of June, 2024.
Obliged, lordship.
In the meantime, the affidavit will be filed.
For admission, item number 9.
My Mr. Lordship, on the last occasion, I've sought time for filing a affidavit in reply.
Hmm?
On the last occasion, I've sought time for filing a affidavit in reply.
Then,
I'll be filing tomorrow itself, so Your Lordship, if the matter may become after a week.
what is your case?
Your Lordship, the petitioner is seeking for grant for appointment on land ownership ground, Your Lordship.
Was so and so appointing as well as a multitasking peon under the year. Under which scheme?
Your Lordship,
Land,
Under-
land,
land ownership, Your Lordship. Why? Because there was a verbal.
land ownership.
Yes, Lord.
Okay. On land ownership basis, on the basis of the post in question. Establishment of so and so. What is their stand?
Your Lordship, the petitioners are claiming for appointment, stating that there was a verbal agreement, but in the department, there are no records.
You have a clause out there, na? If it
Yes,
is a
yes,
verbal
yes,
agreement,
3A.
then that particular, that has to be resorted to, there shall be a decision by them,
Yes, Your
3 or
Lordship.
4.
3A.
Yeah, yes. So, what is that?
Yes, for that, Your Lordship, the petitioners are ready, and then I have
Did you
to get
approach
some.
that?
instruct- Yes, Lordship.
Did you approach it?
Lordship, they are yet to give instruction, Your Lordship, from their side
Huh?
regarding that, Your Lordship. The petitioners are yet to give instruction to me, Your Lordship,
Instructions for what?
regarding the 3A, Your Lordship. Why? Because if there is a verbal agreement, then Your Lordship, they have to get a consent from the Deputy Commissioner, Your Lordship. For that, the steps are taken, Your Lordship.
Understood, but you see that particular clause categorically says, where is that? Yeah. Yes, 3A. In other cases, prior to so and subsequent to setting aside of the Iman when a freely donated land or RIA exists, providing for employment or other to render the claim of the Iman or Iman, the department concerned shall refer the matter to the Deputy Commissioner of the Iman, who shall examine such claim carefully, including whether any employment has been written statement from witnesses that is, these happen?
Your Lordship, for that I have to obtain instruction from Your Lordship,
Oh,
from the petitioner.
is a stay?
No, Lordship.
Stay. How much time?
Your Lordship, 1 week, Your Lordship.
1 year?
1 week.
Okay. The learned counsel appearing on behalf of the petitioner submits that he has to take instructions as to whether the petitioners have availed the remedies available under clause 3A of the office memorandum dated 16/8/2018. Full stop. Or for that matter, as to whether the district, the department concerned have taken due steps in that regard, for which he submits that he requires 2 weeks' time to obtain necessary instructions. List the matter on 28th of June 2024. In the meantime, the petitioner would also be at liberty to file their reply.
Bless Lordship.
For admission, item number 10.
Yes.
Lordship, her pleadings are completed. However, Lordship, the government has constituted a committee by notification 16
Just
February.
1 minute, 1 minute, 1 minute. What is it? To consider the case of the petitioner for scale of pay as the same as regular grade Mali who has been discharging same duties and work as are enjoying. Oh, this is as per that Jagjit Singh.
Yes, Lordship.
The minimum wages. Yes, what is happening in the state of Nagaland? How are you taking care of that? A person discharging the same work,
Lordship,
are you not give for a period of 10 years or more, are you not giving them the minimum of the scale of pay? That is what he's asking for.
Yes.
What is your stand?
Lordship, there is no scheme or policy formulated by the government to grant scale pay to the fixed or contingency employed.
There is no scheme. Scheme is not required. Why do you need a scheme for that? You are only going to pay. This is on the question of minimum wages. Work for what do you call? Equal pay in equal work. That is that concept on which Jagjit Singh came in. That they are entitled to the minimum of the scale of pay, not anything more than that. Isn't that your case?
Yes.
Lordship, may can allow me to make one submission. The government has constituted a committee by notification dated 16 February 2024 to formulate a suitable policy regarding the fixed pay and contingency employed to look into the matter.
There are many cases of this type, na?
Yes.
Pending.
Yes.
The last time when I came also, these type of matters came up.
Lordship, may can be allowed to place this on record.
Now, if this is there, what has happened in the meantime?
Lordship,
Merely framing a committee would not do. By the time you come up with a decision, he may retire.
Yes.
Do something.
because of the busy schedule of the European election,
Huh? Election?
Lordship, European election.
Election, what does this have to do with the election to decide? Your election is long time over. MCC is also over. Then when? You have to work out. If you are doing something, do it, but do something. Because the law is clear on that. If you don't do it, then obviously some action has to be taken. This court has to follow the mandate of the Supreme Court judgment. Very neat case. In Assam also, there was the same thing, where there is the judgment of the division bench. And as such, that judgment is very much applicable here. Upen Das.
Yes.
You have it. Writ Appeal 41
Yes.
of 2012.
Yes.
2017. So that judgment is squarely applicable here, isn't it? So he's entitled to. When are you doing it? Something?
Lordship, currently allowed some time,
How much?
3 weeks.
Lordship, let the matter become after 2 weeks.
2 weeks?
Yes, Lordship.
No, 3 weeks. Let them come up with an affidavit as to what further steps have been taken. Let them file an affidavit.
Yes.
I think then it is a better work. Don't you think that? This is a petition filed by the petitioner claiming the minimum scale of pay as a regular grade 4 employee on the basis of equal pay for equal work, and in view of the judgment of the Supreme Court in the case of Jagjit Singh versus State of Punjab reported in so and so. Ms. So and so, appearing on behalf of the respondent, submits that the government is actively deciding the said aspect of the matter, and as such have already constituted a committee by the notification dated 16/2/2024. She submits that on account of the recent elections and the model code of conduct being operational, further progress could not be made. She therefore submits that she may be permitted to apprise this court as to what the said committee what steps the committee have done, and as such seeks an accommodation of 3 weeks. List the matter again on 21st of June 2024, on which date the respondent, who is the main respondent? The respondent number on which date the respondents shall file an affidavit bringing to the notice of this court as to what further progress have taken place in respect pursuant to the constitution of the committee by the notification dated 16/2/2024.
Much.
For admission, item number 11.
Yes.
May this Lordship just received a reply in affidavit. I've just received the reply in affidavit.
You'll
So
file a
let the
reply
matter-
affidavit.
Yes.
Compassionate appointment.
Yes, my lord.
As per, you have a particular
Yeah, memo, as per office memorandum
2015,
2015
and
and
dated
addendum
11/2019.
dated 9/4/2019. My lord.
They filed the affidavit.
Yes.
When?
Today itself,
or today?
yes.
No, they filed the affidavit on 35.
So
Okay.
let the matter come
Mr.
up a week, after a
Miss-
week.
The learned counsel for the petitioner submits that taking into account that the affidavit has been filed, the affidavit, a copy of the affidavit in opposition have been served upon him during the course of the day. He seeks 3 weeks time,
1 week,
1 week time
yes.
for the purpose of obtaining instruction as to, for the purpose of taking for the purpose of filing a reply.
I won't reply, my lord.
Huh?
I'll just go through and.
Okay, submits that he a week's time so that he may either file a reply or proceed with the instant matter after taking appropriate instructions from his client.
Yes, my lord.
List the matter when?
1 week.
1 week. 1 week is when? Next week when? Everyone 13? 13? 13?
Let the matter come up on Friday, my lord.
Next Friday?
Next Friday, Your Lordship.
Next Friday?
Yes.
14th?
Yes.
14. Much obliged. my lord.
For admission, item number 12.
Mr. Lordship.
Yes.
Lordship, I'm yet to file my counter, Lordship, so kindly grant me some time, Lordship.
You've taken.
I've
lot of
taken
time.
the. Lordship.
What is he asking for? Oh. The Ms. S. Xiang, the learned junior government advocate, seeks for a further
3 weeks, Lordship.
3 weeks time for filing the affidavit. It is seen from the reports that various opportunities have been granted to the petition respondents for filing their affidavit. First, and the last of which is on 2/5/2024. Accordingly, this court fixes the matter again on 25/6/2024. The affidavit be filed without fail by 21st of June 2024. It is made clear if such affidavit is not filed or not before the next on the date as so fixed, this court shall dispose of the instant writ petition on the basis of the pleadings already on record.
Obliged, Lordship.
For admission, item number 13.
Your Lordship, kindly grant me 3 weeks time to file my affidavit.
Same.
Yes, Your Lordship.
What are you asking for?
Lordship is seeking for pensioner benefits, Your Lordship.
Huh?
Pensioner benefits, Your Lordship. Service regularization along with pensioner benefits.
Impugn order dated so and so, impugn order. What is these orders for?
Your Lordship, those impugn order are the, Your Lordship, two scheme, Your Lordship, regarding 2004 and 2015 memorandum, Your Lordship.
Ah.
And then I've challenged some clauses, Your Lordship, from the set.
Why you are challenging this?
Yes, Lordship.
And what is this? Why you are challenging it?
Your Lordship, in short, Your Lordship, by 2015, it says that if works are employed in 30 years on scale, they'll be regularized. But then the petitioner, like me, Your Lordship, I entered service at the age of 35. And then after serving 25 years, Your Lordship, I've been released on superannuation, Your Lordship. So there's some discriminatory, Your Lordship. So on that basis, Your Lordship,
So as of now, you are no longer in service.
Your Lordship, I've retired, Your Lordship, on superannuation, Your Lordship.
When did you retire?
23, Your Lordship, 2023.
And you filed then? 2023.
Yes, Lordship. On 4/12/2023.
And you retired on?
I was retired on 11/4/2023.
And you filed it on 4/12.
Yes, Lordship.
Why?
Your Lordship, after the retirement only, I got the instruction, Your Lordship, from the petitioner.
Understood. Yeah, we'll presume that you are the petitioner.
Yes, Lordship.
I am not asking you as a counsel. I'm asking why the petitioner waited all this while. He knew about the 2004. He knew about the 2012, 15. He knew about the 2021.
Yes, Lordship.
He retired on 11/4
Yes.
and you filed it on 4/12.
Your Lordship, before my retirement, Your Lordship, the department was trying to regularize my service, Lordship, for which I've enclosed all the annexures, Lordship.
How?
But then,
How could he be regularized in terms of the 2002? You were not in scale.
I was on scale, Your Lordship.
So then how do you say, because isn't that a policy of the government, the office memorandum?
Yes, Lordship.
Then how can this court say that the policy is bad unless you show there is a gross arbitrariness?
Yes, that's why, Your Lordship, for that reason, I've challenged those policy, Lordship, some clauses, Your Lordship.
But wouldn't it be very late for in the day to do so? You
Your
were
Lordship-
on the all along in the scale of pay. Why didn't you challenge it?
Last year, only in the year of 2023, only, Your Lordship, the government, Your Lordship, they have rejected the department's prayer, Your Lordship, for regulation of my service.
Because you can't be regularized. In view of the 2015, you knew it.
Yes, Lord.
As on the date on which 2015 came, you knew it that you would not get 25 years, 30 years, isn't it? Then
Your Lordship, for that reason, Your Lordship, even though I'm in seniority 1 or 2, Your Lordship,
and that too, when the division bench have already held that 17/3/2015 is good.
Yes,
See, there
Lord.
was a challenge made to the effect as regards the 50 and 63 plus 67 it was, no? There was, in the meantime, there was an increase by what clause out there in the 17/3. No? I remember this judgment, can you see here? Is the 17/3.
page 40,
Page
40.
Yeah, 67, I'm right, page 41. The existing scheme for regularization of area against normal vacancy is being modified and the quota of work charge employees stands enhanced from 50 to say for 5 years effective area. Because there was a single judgment which held that after 2020, this was no longer available. Matter came up before the division bench says that no, so far as 2004 Act is concerned, office memorandum, so far as it does not, or it would only remain so far it is not contrary to the 2015. Okay. They filed an affidavit. You want to file an affidavit in this type of matters? You want to file? Then also. Then why you are not filing it?
Your Lordship will be filing.
We have taken 3 adjournments. Why? 439435. He has already retired. 11/4.
Yes, Lord.
At least file the affidavit, let him know why he is not entitled to. Ms. So-and-so, the legal counsel appearing on behalf of the respondent submits that she needs another 3 weeks' time for filing the affidavit. It is noticed from the order sheet that on 4/3/2024, 9/4/2024, 3/5/2024, adjournments were taken and the time was taken for filing the affidavit. However, no such affidavit has been filed. Under such circumstances, for the interest of justice, another 3 weeks' time is granted to file the affidavit by on or before 21st of June 2024. This is the matter on 26/6/2025. 25/5/6/2024. It is made clear if the affidavit is not filed by the state on or before the next date so fixed here in above, the instant petition would be taken up for disposal on the basis of the pleadings already on record.
Obliged, Lord.
For admission, item number 14.
Yeah, please, Your Lordship.
Same prayer.
Yes, still have yet to file.
What is his
affidavit.
case now?
Lordship, seeking up credit for appointment on land ownership basis.
Huh?
It's a private-
Was the appointment order to direct the respondents to dispose of the representation, direct the respondent to consider the case of the Mira post of sale scaleman at ADSA in terms with notification dated 5/3. 5/3 is that landlord and land ownership. What is that 5/3?
Page 23.
Land ownership. Now, they have not considered this.
Not yet. Your Lordship, I'm yet to receive instructions, Your Lordship.
Why you not considering it as per this? Consider it 3B. They say you have a verbal agreement or written agreement.
Written agreement.
Written agreement. If it is a written agreement earlier, then the question is, it will be wherein a specific written agreement existing, providing for here the claim of the aware shall be settled in terms with such agreement. 3A. You come under 3A. Then why you have not been considered? As and when any vacancy arises, preference shall be given to the landowners for appointment to the grade 4 staff. Why you are not doing it?
Your Lordship, instructions regarding vacancy, I'll have to.
Understood,
Yes,
but how you are
consider.
appointing somebody then?
And that's for
You have
temporary.
appointed somebody.
Ah.
11/11/2019. Is he appearing? Who is appearing for that respondent?
Yes, they have completed the private response.
Number of service is
5.
complete?
Yes.
Yeah.
So with regards to this private respondent, it's just temporary in nature, not permanent, Your Lordship.
Private respondent appeared on 21/3/2024.
Now, has anybody appeared for 5?
Yes, on 23 March.
21/3/2024.
March, Your Lordship.
Miss Nagali Sohe, Learned Counsel for Respondent with consent of the other pays for listing the matter of the 3 weeks. The learned government advocate is granted 2 weeks time to file affidavit in opposition. And Mr. Counsel, how did you know about this? In 2019, the appointment has happened and you have woken up in 2024? The learned counsel appearing on behalf of the state 6 for 2 weeks time.
3 weeks, Your Lordship.
3 weeks time for filing their reply affidavit in opposition. It is noticed that that on various occasions, time had been taken by the government advocate for filing the affidavit, but no affidavit has been filed. It is also seen that respondent number 5 is not represented. He is neither represented nor have filed any affidavit in opposition. Taking into account the above, list the matter on 27th of June 2024. The respondents are given the last opportunity for filing the affidavit
Your Lordship,
on or before 25th of June 2024.
can we make it 4 weeks then, Your Lordship?
What?
If it's going to be a last chance.
It is almost 4 weeks. Today is third.
Yes.
Third entire week from now you are at 12. You have the entire day. Then 3rd to 10th is 1 week. 10th to 17th is 2 weeks. 17th to 24th, 3 weeks.
Your Lordship.
So you get 3 weeks, 3 days. I'll have it.
Your Lordship.
For admission, item number 15.
Your Lordship, here also state is here to file affidavit, so kindly wait for 3 weeks time. State is here to file affidavit, Your Lordship.
Yes, madam, what is your case?
Lordship, it pertains to regularization on the basis of
Land
seniority.
ownership or
No,
what?
seniority.
Seniority.
Yes.
How are you senior?
As prepared by the
You
district.
were, are you anywhere appointed in any other post?
I was appointed as sweeper.
Now, what do you want? To appoint the petitioner to the post of sweeper grade 4.
Yes,
Sweeper is
Lordship.
grade 4.
That has been redesignated as MTS. All those
On the strength of being the senior most senior. And for a notification dated passway be quashed. For regularization, appointment and appointment on compassionate ground to grade 4 under the Department of Air. Yes, madam?
I'm here to file my affidavit, so kindly grant me 3 weeks time, Your Lordship.
Time?
Yes, Your Lordship.
How much?
3 weeks, Your Lordship.
No. I have no work next week. All the matters are getting adjourned. What to do?
Yes, Your Lordship, kindly make it 2 weeks then.
At the request of the, you are appearing for private respondent?
yes,
You are filing an affidavit?
I filed this morning.
File it.
Yes,
When? Today?
this morning.
Okay, the learned state council.
Lordship, 2 weeks may be given to file a reply to the affidavit in opposition.
Yes, the learned state council. So 6 for 3 weeks time for filing their affidavit in opposition. The council appearing on behalf of the respondent number 4. 4.
Yes, sure.
4. Submits that during the course that the affidavit have already been filed on behalf of the respondent number 4. The council appearing on behalf of the petitioner submits that she may be granted some time for obtaining instruction and then to file the affidavit in the reply. Just list the matter again on, you are having summer vacations? No, this is principal seat. Look, why are you giving this principal seat? Is the matter again on 1st of July 2024. In the meantime, the replies and the affidavit in opposition as well as the reply to be filed by the state as well as the petitioner respectively.
For admission, item number 16.
Your Lordship, petitioner seeking for appointment on compassionate ground.
Your Lordship, I'm yet to receive instructions. However, Your Lordship, I'd like to just submit that proposal of this petition. These petitioners overage to avail this scheme. Your Lordship. The petitioner had made her application on 2023. Petitioner was already 42 years, Your Lordship. 42 years of age. And the petitioner made his application. And as per the scheme, the relaxation can be made only to a maximum of 5 years. That's the existing upper limit. Page 32 of the petition, Your Lordship. Page 32. It's the revised compassionate appointment scheme of the state. Para 8. Page 32, para 8. And Your Lordship.
What is the age limit?
As per the scheme, it's the upper age limit of an applicant under this scheme may be relaxed in exceptional cases up to a maximum of 5 years, in addition to the existing relaxation. So the upper age limit is 35 years. Your Lordship. Till 40. That is the maximum.
There is no such specification. There is no age specification in this office memorandum. Yes, but it can be granted 45, up to 45. Yes. Actions. Yes, scheduled time. So it is 40. It's 4 days.
Taking into account that the petitioner is the maximum relaxation, after maximum relaxation, in terms of clause 8, the candidate cannot be more than 2 years. Taking into account the so fixed here below. The notification issued by the government of Bangladesh and that's the age limit and also as to what other relaxations are also list on Friday day.
For placement.
For admission, item number 17.
Lordship, on the last revision. We have already, it's on the private respondent. Serving, issuing notice on the private respondent.
Private notice, no notice of any issue.
Yes.
By the instant writ petition, the petitioner herein have challenged the order dated 17/8/2023, whereby the respondent number 5 have been given an appointment by be it as it may, it is seen from the order dated 25/4/2024 that only notice was issued upon the respondent number 1 to 4, but there was no notice issued upon the respondent number 5. Under such circumstances, this court issues notice upon the respondent number 5, making it returnable on 2nd of July 2024. Steps be taken by way of registered as well as usual within 2 days. Full stop. In addition to that, the the respondent state is directed to file their affidavit on or before the next date.
From the supplementary course list for admission, item number 40.
Here, what is this?
Your Lordship, the petitioner is challenging his recovery of his leave encashment and gratuity, and also the additional amount of around 5 lakhs, which was ordered to be deposited to the account of the central government, Lordship. Lordship, you will find it at page 38 and 39, Annexure 8 and 9, Lordship. Lordship, what happened was the petitioner was discharged, first discharged on 15th May 2010, and then by a series of proceedings, he was reinstated on 19th September 2015, Lordship. And then after that, he continued in service, and then he was again discharged on 22nd March 2021. And in the second discharge, he was allowed to go on compulsory pension. So during that time, he was the respondents had found that there was an excess payment of rupees 12,23,660 rupees made to the petitioner, Lordship. And because of this, his pension has been withheld till date. And from the amount of 12 lakhs, total amount of 12,23,000.
They have already taken the
Yes,
gratuity and leave encashment. And
yes,
remaining
Lordship.
is another 5
5
lakhs
lakhs.
demanded from you.
Lordship. So, Lordship, we are praying that our contention is that this is illegal, Lordship, because first of all, his gratuity and leave encashment has been deducted, and another 5 lakhs has been ordered to be deposited to the account of the respondent's lordship. Lordship, our case is squarely covered by Rafiq Masi, lordship, which is enclosed at Annex 10, page 40, lordship.
Let us see the facts properly.
Lordship.
Rafiq Masi will come. Rafiq Masi says about to that effect that you cannot at the time of retirement take over
Lordship.
all this money.
Lordship.
That I understand, but well, let's see over the facts how it is. You have a list of dates out here.
Yes, lordship.
Where does it say?
Lordship, he was appointed as, he was enlisted as rifleman general on general duty in the 42nd Assam Rifles on 1911-2000, lordship. And then his first discharge was on 15th May 2010, which is at Annex 1, lordship.
Now you filed a petition challenging that earlier one.
Yes, lordship. It's still pending. Not the earlier one, lordship.
No, it is pending as regard the compulsory discharge.
Yes, lordship. It's the
Compulsory,
second, lordship, the second discharge, lordship.
When is that matter coming up? Should we
Lordship,
not tag this matter with that?
no, lordship, these are not connected because this recovery was made
No,
from the
just for
earlier
example,
discharge. Lordship.
let us take a situation where that requisition becomes maintainable, or
Lordship.
that order of compulsory discharge is interfered with.
Lordship.
Then whether the question of gratuity will come, leave encashment will come. No, these things won't come in. But
Lordship.
today, if I decide that as regards the gratuity and ER on the basis of Rafiq Masi, then your earlier petition becomes useless. Don't
Lordship.
you think that? What do you say?
Lordship.
There are two petitions.
Eh?
Two petitions pending. One is this and one for against the discharge. So unless the other petition is heard first, so we cannot decide on.
Yeah, that is what. If that petition is not decided first, I can't decide. Because then, how can I, if that is allowed, today I decide out here, yes, you cannot deduct on the question of this. Otherwise, you have age. What is your age? You're just 36 years.
Yes, sir.
So obviously, then you will be entitled to much more. So
Lordship.
under such circumstances, if that is decided in your favor, these will go.
Lordship.
Then the question of recovery of whatever may be, that will be, that aspect will remain. Then it will be a total recovery, which will be another aspect of the matter. Whether that recovery at all is permissible. Then we need not go to Rafiq Masi. But as regards the illegality, then they have to show that how they have made the recovery.
Lordship.
Okay.
Lordship.
This matter, upon hearing the learned counsel appearing on behalf of the parties, it transpires that prior to the passing of the impugned order, dated 13th of May 2022. The petitioner herein was discharged by an order dated 22/3/2021. And in that regard, the petitioner had also filed a petition being WPC number 212/2022, which is presently pending. So it is the opinion of this court that without deciding the petition being WPC number 212/2022, the instant writ petition cannot be decided. Accordingly, this court therefore directs the listing of WPC number 212/2022 along with the instant writ petition on when
After a week, Lordship.
when
13th June, Lordship.
huh?
13th June, 1/3.
13
13th
6
June. Yes,
6
Lordship. 13/6.
13/6/2024. Pusta. The learned counsel appearing on behalf of the petitioner further submits that in the meantime, no coercive measures should be taken for recovery of the amount of rupees 5 lakhs. How much?
5,22,101 rupees.
5 lakh
201.
22,201 in terms with the impugned order. This court, having taken into account the materials on record, is of the opinion that if a stay is not granted to the recovery of the amount of rupees 5,22,201, the petitioners would be severely prejudiced. Accordingly, this court directs that there shall be no recovery of rupees 5,22,201 till the next date.
Lordship.
With the disposal of the petition, with the disposal of the instant petition.
Lordship. Much obliged, Lordship.
For orders, item number 18.
Lordship, by the last order, the registry was directed to take steps upon the petitioner, Lordship.
Yes, steps taken.
Lordship, that I am not aware, Lordship, whether registry has taken steps or not.
You are the petitioner.
Yes, I am for the petitioner, Lordship.
Then what steps are required to be taken by you?
As per the order, the direction was given to the registry, not to the petitioner, Lordship.
What is there? Why steps is required to be taken? Notice was issued but returned unserved with a comment insufficient area. Why you don't have connection with that?
No, Lordship, no.
Why?
I have a phone number, but no calls are being picked, Lordship, and it's been several months now, Lordship.
You must
It's been
have
quite some
lost
time now.
interest.
I have tried my every
the official-
possible efforts have been made, Lordship, to establish communication with the petitioner.
This for information here. Then how do you tackle it? What does he want?
In fact, I have.
Where is the official rules? Then how do you, what type of address is this? Resident of Midland, Kohima? Where is Midland?
Midland is somewhere in the town, Lordship.
How big? How many people reside? 10,
Yes,
12,
Lordship.
how many?
About 1,000 households, Lordship.
Then you put your address like this. You can't escape yourself. You have to do the matter. You can't escape like this.
No, Lordship, at the same time, I cannot.
No, Mr. You cannot come up and say, I have lost contact. You have taken this address and you have put it in the repetition in this manner.
Yes.
You
No,
must have
Lordship,
taken
in
a
fact-
phone number, whatever maybe. This is the phone number. Have you called up this number?
The earlier council, Lordship, the original
Oh.
council, he expired, Lordship.
Intimela Long Kumar.
Yes, Lordship. And the.
Have you called up this number?
Yes, Lordship.
What happened?
They're not picking, Lordship.
They're not picking me?
No, Lord. They're not picking the phone.
Picking or what? Does this number exist?
Yes,
In the
Lordship.
name of
But
this
yes,
person?
yes. When there is no answer from the other end, Lordship, in short. And Lordship, this petition, it was filed by another council who expired, Lordship.
So now how did you come in between? How did you come into the picture?
Lordship.
The petitioner must have been.
Yes, Lordship.
Then, however, we are not
But at
bothered.
that time, Lordship,
Why you have taken this type of address? You have must have taken a better address from them.
now, yes, Lordship, that is there, Lordship, but now.
Now, therefore, being a lawyer, it is your responsibility. Anyways, you do PIs. Think it this will also be a PI.
No.
Do the math.
Lordship, actually, I wanted to ask her some questions, Lordship.
No, if they don't give it, you are
But
not in a
now,
position.
since I'm unable to make communication
No,
with her.
whatever
Lordship.
may be, if you are not in a position to get it,
Yes, Lordship.
then the law will take its course. Because you could not serve upon them.
Yes, Lordship.
Your relationship with your client remains till you intimate him or
Yes.
her that look here, I'm no longer there. You have
Yes,
not
Lordship.
till date. So your relationship with your clients continues. What do you say, madam?
Then in that case, Lordship, I may be allowed to take steps, Lordship.
What steps?
I'll try another time, Lordship, to establish communication with her, Lordship.
Go and search out there in Midland. You have put an address like that. You can put the.
Yes, I am told,
the postal department in this state of array.
I have received information that she does not reside in Kohima anymore, Lordship. That now that is the difficulty, Lordship.
What is it challenging? Let's see.
Her termination, Lordship.
To continue the petitioner in service as Miguel Tizit under the establishment of Imam Bond, releasing the pending salaries. That means is he not working?
No, she's not working anymore. She has been terminated from service, and against that termination, Lordship, she has approached this honorable court.
Okay, where's the termination? Let's see. How is she terminated? Where's the termination order? Okay, so and so is temporarily appointed in the post of medical attendant in so and so. The appointment is purely there may be terminated by 1 month's notice given either side at the time without deciding reason. This happened in 2010.
Yes, Lordship.
Then
Now, in the representation that she has met, Lordship, before the respondent now
where is the termination order?
it is not part of the.
Then
Lordship, only verbal instruction was received, Lordship.
Yes, madam, what is your stand?
Services were terminated because the appointment was illegally done, Your Lordship.
Appointment illegally done?
Yes, Your Lordship. The
Chalo.
appointment, the appointing authority.
We complete this matter tomorrow. Today, we say your termination is you cannot be terminated.
My lord.
No, your service cannot be terminated with your client.
Okay.
Unless you confirm me, and as such, we'll take up the matter tomorrow.
My lord.
At least something good must have happened.
My lord.
There has to be a closure because otherwise, if a person is otherwise interested in a matter, definitely he would have approached the council.
This Lordship. My lord.
This court have taken into account the materials in the court.
Lordship, then can it be on Thursday, Lordship? Thursday, Lordship.
Is it a good day?
Lordship, I want to look for some rulings, Lordship.
This court have heard. This court have heard Mr. Sentianger, the learned counsel, who submitted that he has withdrawn the wakalatnama on a specific query being made to the learned counsel appearing on behalf of the specific query being made by this court to the said counsel as to whether the fact that he has withdrawn the wakalatnama have been duly informed to the petition. The learned counsel submits that the same have not that he had not been able to communicate the said respective
My lord.
matter. Under such circumstances, in the opinion of this court, the relationship between the said counsel as well as the petitioner does not cease till the petitioner is duly informed. Consequently, this court would take up the matter for disposal on 6th, and this shall take up the matter for disposal on
Thursday, 6th, my lord.
6th of June 2024. Taking into account that the instant writ petition is of the year 2017 and the termination challenge is of the year 2012 and more than a decade has passed.
Much obliged.
For hearing, item number 22.
Yes, Mr. Counsel, did that matter finish off? I heard that matter, then I couldn't complete it just before leaving.
Which one, madam?
There was one matter pertaining to a person being excommunicated. Was that the matter you were doing?
No, my lord.
No, there's another counsel.
Yes, it's another counsel.
Yes, what is your case?
Lordship, this is
Come up
about
for hearing?
Yes, madam, this is for hearing. This is about denial of consideration for promotion. There are two head petitioners.
Denial of?
Consideration for promotion, complete denial. A ban, in a manner of speaking.
Ban?
Yes, madam. And that has been through a seniority list. You should find that at page.
Let's see the facts.
The facts, madam? Yes. First, we go to page A. Paragraph 4.
So in 2012, in the tentative seniority list, you were there. Thereafter, on account of your qualification in the final seniority list, you are out.
I am there.
Okay.
I am there, but then there is a saying that I am not.
Kindly come to paragraph 11 of your petition.
Yes, madam. Yes. Qualification of that. What I have said here.
So because of the qualification not being there,
Yes.
this
was introduced for the first time.
Which one?
This what I'm saying is paragraph. Okay. Because all along I was in the department.
You were in the
In the
department.
Yes.
Yes.
My name was there. Yes. Only when the senior list of 2018 came out. There for the first time, we said that you don't have the qualification, be in the civil wing.
When did this come out?
It came out on 26/3/18.
Then why did you were not there in 2016?
Your Lordship, we came to know that the move was being made.
So against the move you went.
Yes.
Okay. Office memorandum. Seniority listed in the senior names of the act for in the notes certificate course of others. Oh, you had a certificate course.
No, we are diploma holders in mechanical engineering.
Okay.
And they are the certificate holders also. But we are diploma holders in mechanical engineering. So on the ground that we are diploma holders in mechanical engineering, this rider was put in this list that we are not eligible for.
Okay. Now, what does the rules say?
Yes, ma'am. The present rules is of now with the rules of 2012.
So at that point of time, you entered into one entered in 2006, regularized, and the other in 2009. So at that point of time, what was the rules?
When 97 rules.
Huh?
The 97 rules. 97 rules.
Okay. Now that rule, is it there? What happened to those 97 rules? Have they?
This is more or less in private material.
Okay. So there's no conflict.
Not much.
Let's see what is the qualifications required.
Your Lordship, the first one is, if Your Lordship come to rule 2, the scope is applicability. These rules shall apply to all persons appointed in the National Union Service Group A and Group B in Public Works Department, Public Health Engineering Department, and Fire Department. We are concerned with A, Public Works Department.
Yours is some housing department?
Yes. So the works and housing is actually Public Works Department. And the public health
Works and housing NPW.
Yes. So we are in 2A. Public health engineering department is a different department. We are not concerned with that. And fire department is a different department. That also we are not concerned with that. So the point I'm trying to make here is that mechanical, civil, all come under PWD. Now, if we can come to the schedule.
Yeah.
Schedule and 6. Schedule 6. Schedule 7.
SDO?
Schedule 7.
Schedule 10.
7.
7.
Okay. 7.
We are concerned with
We are concerned with promotion
number
of-
6, subdivisional officer.
Yes, madam. 6.
Promotion and direct recruitment, 60-40, 60% of the post shall be filled by direct recruit from amongst the degree holders in the concern. So
In the concerned engineering discipline.
40% of the post shall be filled by promotion from amongst the degree diploma holders in the concerned engineering discipline who have completed a minimum of 7 years of continuous service in the in case of diploma and 4 years in the case of degree holders. So if it is a diploma holder, then he requires 7 years in the lower grade and the degree holder is 4.
Yes,
You say that you have a diploma.
Yes, madam. And the rules say in the concerned engineering field, there is no distinction between mechanical or civil. That is the point, madam.
And that is finished.
Not yet, madam. Not yet. But there is a slide which I must place before you. And in the civil wing, in the works and housing department, there are different wings. And you must find that in beginning from schedule 1.
Okay.
That's important. So this is from engineer chief, etc., etc. Various categories of posts. Then OP service, junior engineer, and this is for, if your lordship will see on top, civil engineering. Civil engineering. Your lordship got that? Then next is
architectural wing.
Yes. Architectural wing.
Mechanical engineering.
Schedule 3 is mechanical engineering.
Electrical engineering.
And
Electrical inspectorate.
Schedule 4 is, here we are not concerned.
Public health engineering.
Electrical, etc. These are different departments. So we
They
have
don't have for the housing.
housing also is.
Which one?
But
housing will form in the
under works and housing.
civil engineering.
Yes, will come as a civil engineer.
And
so that we are only.
So they say that for housing they don't have.
They say that for civil engineering, mechanical diploma in mechanical engineering is not the qualification. For the civil
But this is the schedule 1 is as regards the scale of pay.
Yes, madam.
Schedule 1 to schedule 5 is only in respect to scale of pay.
Scale of pay and the categories of posts.
And the post.
Yes, madam. Categories of posts.
Diploma means diploma from a recognized polytechnic public institute. Strength of service and pay scale attached. Procedure for direct. We are concerned with promotion. No?
Yes, Lord. Yes, Lord.
Where is the year for promotion?
Promotion again in schedule.
No, not there. This is all appointment by promotion. Yes, sir. 16. Initiate the action for filling up the anticipated thing of the department section.
Just general provisions, madam. Nothing about qualification. And of course, the constitution of the degrees.
So we have to read rule 7 with schedule 7.
Yes, sir.
Now, what is their case? Respondent's case.
The respondent's case is simply this, matter, that I hold the diploma in mechanical engineering and I cannot be in the civil engineering side.
Yeah. You don't come within the civil engineering.
Yes, sir.
So where do you fall in?
Nowhere.
The very serious thing.
Your Lordship,
Because that is the only thing.
That is the
From the
only thing.
rules I can find, they don't have the housing department.
no, Your Lordship, I have stated in paragraph 5, Your Lordship, the stand of the government is that, Your Lordship,
Paragraph 5 what?
paragraph 5 of my affidavit in opposition, Your Lordship. Lordship, in my paragraph 5, I have stated that the NPWT, that is Nagaland Public Works Department, under this, Your Lordship, the Qatar or Department of Civil Engineering Wings, Your Lordship, consists of PWT R&B, Road and Bridge, PWT Housing, PWT National Highways, PWT Planning and Design, Your Lordship, whereas mechanical engineering consists only of
Now, who inserted them in the mechanical engineering?
Your Lordship,
You did it. That
Yes,
is
Your
your
Lordship.
fault. And for that, he could suffer. You have to then put him into the mechanical engineering if you feel like.
Your Lordship, the
If
entry
it is
point.
not there in the civil engineering, nothing out there, it is for you to do that. You can't do them. Isn't that?
Yes, ma'am.
It is your mistake.
Right from
Why
the
did you
inception.
enter him in out there?
Inception is a problem because they were appointed on contract basis.
And if
So
he is in the mechanical engineering, then he gets the benefit.
he should be good because mechanical also they maintain a separate seniority list. Your Lordship.
Understood. But
Yes, Your
then
Lordship.
you are not, you see, if we see schedule 7,
Yes, Your Lordship.
schedule 7 is in respect of
Promotion
all.
to the.
Schedule 7 is
40%.
in respect of all posts,
Yes, Your Lordship.
irrespective of anything, all posts. Now, SDO, assistant engineer, assistant architect. So anybody who has 40% who has to be followed up from there, and if he has a completed 7 years of continuous service in the intermediate lower grade in case of diploma holders and 4 years in case of so and so. This does not say anything as regards now in civil engineering, you don't have the post of the SDO. It is there.
It is there.
Then why you are not putting them?
Your Lordship, that is the instruction I have received and that is, I have included in the affidavit only, Your Lordship.
No, understood.
Yes.
But
Now-
in civil engineering also, you have the SDO post
Yes, Your Lordship.
as well as the assistant engineer or deputy estate officer, you have it. Now, why you, because you see, if we read, you are differentiating with civil and schedule 1 with schedule 2, schedule 1 with schedule 3. Schedule 3, they have assistant mechanical. Now, his diploma is in mechanical engineering.
Yes, Your Lordship, mechanical.
Now, if he is in the mechanical engineering, does it say that a person who has a mechanical engineering cannot be appointed in a civil engineering?
Yeah, that is what I am apprised of, Your Lordship.
Where?
So, Your
No,
Lordship,
let's see the rules. Where does it say?
Your Lordship, the only.
No, here you see, kindly see here. Diploma. Diploma means diploma from a recognized polytechnic.
Yes, sir.
What is his qualification required? Kindly see 7. Recruitment to the service shall be done either by direct recruit or by promotion. The qualification for direct recruit, criteria for promotion to various grades of service and ratio of quota for direct recruit and promotion at each grade at the commencement of these rules shall be stipulated in Schedule 7. Now, Schedule 7 does not distinguish.
Yes, that is there, Your Lordship.
Then how do you take them out? Either you have to put it in the mechanical or in the civil engineering, they have a right. There's nothing out there. Where is it mentioned that if a person who is, first of all, it is you who have done it. They were all along working as regular, you regularized and brought him out there. You cannot deny him.
Your Lordship, as far as the maintenance of the seniority list of the mechanical are concerned, Your Lordship, since the seniority list of the mechanical are also being maintained, Your Lordship, let me seek an instruction as to.
For what?
Your Lordship, because I've been apprised that mechanical wing, they have engineering.
You
they
can take an
maintain-
instruction and say that all along we have made the petitioners suffer. We are taking remedial action within a week's time. Take that. Something to that effect. Not in respect to you are going to what instruction. What is the instruction out there taking into account your stand? Your stand is clear.
Yes.
That you made a mistake with putting them in mechanical. Civil engineer, you should have put him in mechanical. And did you at that point of say, inform him that look here, if you are in mechanical, we are not going to give you anything to that effect. And the rules out there do not prohibit.
Yeah.
You don't have the engineering, you can't help it. That is your lookout. Okay, well, we'll do one thing. We'll have it on Friday. Get your instruction.
Tomorrow?
Tomorrow.
I can just seek
Okay.
instruction.
Upon hearing the learned counsels appearing on behalf of the petitioner, Ms.
Livika, Your Lordship.
Appearing on behalf of the learned, hearing upon, this court had duly heard the learned counsels appearing on behalf of the petitioner as well as the respondent state. Upon hearing, the Ms. Livika submits that she would like to take instructions as to why the petitioner's hearing cannot be promoted, cannot be granted promotion. More so when there is no clear stipulation in Rule 7 of the Nagaland Engineering Service bracket Group A and B bracket close Rules 2012, as well as the Schedule 7, Roman 7 attached thereto. List the matter tomorrow. Showing it as part of it. Yes.
Item number 27 to 57. The council for the police department has had this letter of action still with this day. So, my lord, may this letter be listed on Thursday for hearing.
Which one?
As a fix, 27 to 27 to 27. This is pertaining to appointment of constables.
27 to 37.
Yes, 27 to 37. Appointment of constable without advertisement, lordship.
Who has given the letter of excellence? E.B. Jamil.
Yes, yes, he is the respondent for all the respondents.
Taking into account that Mr. T.B. Jamil, the learned counsel, have no, I won't adjourn it on that ground. I say that on Thursday.
On Thursday, lordship.
Because if I do it, I'll be then stopped later
Lordship,
on
lordship.
in respect of other counsels.
As a fixed item, lordship, it has been dragging on. So as a fixed
I
item.
remember these matters came up before this.
Yes,
on the
yes,
last
lordship.
occasion. Okay. List of 27
In item 120,
27 to
119.
37, huh? List the matter again on Thursday. On which date an attempt shall be made to dispose of this.
Lordship. Obliged, lordship.
Okay, thank you. Rule do online debi nahi to. Tagan law website pe has not been updated since 2021. Maybe moi on the parata to available nahi.
Taka masalah 2 minutes.
45 minutes deadline.
Asana na ko.
Ini proses judicial dua. Disposal, treatment.
文多少位啊？文多少位？我只是留着外带。
Well, one is 2024.
May it please my lord. Lordship, I beg to mention hearing item 23, Lordship. Lordship, there is a technical difficulty in this case, Lordship. In that, since my case is covered by the division bench decision passed in Writ Bill 35 of 2022, Lordship. However, Lordship, the state, I am told that they have preferred an SLB before the apex court, Lordship.
20.
My lord.
What is that matter about?
For regularization, Lordship, the petitioner, he has served for 35 years. He was superannuated. And then he was made to go empty-handed, Lordship. The division bench in Angpe was the state of Nagaland, Lordship. The single bench allowed the writ petition, Lordship. The state preferred an appeal before the division bench. The appeal was dismissed by the division bench, Lordship. Now, state has again preferred an SLB before the apex court, Lordship. However, because of the vacations, I am told it will be listed after the vacations, Lordship. So, which is why, Lordship,
Request,
Your Lordship,
yes.
may I, Your Lordship? Your Lordship, here, the state is under the impression that the petitioner is similarly situated with the petitioners in that division bench matter. But Your Lordship, here, the facts is different. So we want to contest the case, Your Lordship.
You want to?
Contest the case, this case. We are under the impression that the petitioner is similarly situated with the petitioners in that DB matter, where the state is contemplating to file an SLP against that order. But here the facts is different, Your Lordship. In fact, the present case is clearly covered by the ratio laid down in that Alanbas case, Your Lordship. The petitioner is claiming. Oh, if that's the case, Your Lordship, yes. Let it be listed after 4 weeks, Your Lordship.
Okay, let me first take up Mr. Joshua's matter. That is a motion matter, no?
For motion, item numbers 1, 2, 38, and 43.
May I please, Your Lordship here, that the notification dated 4th March 2024. As per the rule 6 it is mentioned there. And accordingly, those are the copies. That ARO, it was intimated to the ARO, that is Electoral Registration Officer is in Obutu. ARO has issued a circular and inviting all the stakeholders. Then they had a meeting and everything was informed. Then those are the list attendee of those stakeholders, those who have complied with the direction of the ARO. So that way we have already notified to the voters, the electors.
So it has been duly informed about the draft rules.
Yes.
On 8th.
Yeah, not in the.
On 6th, it was informed.
Yes.
And on 8th, it was fixed.
Yes.
Or on 8th, it was informed. And
Meeting was scheduled on 7 March 2024.
Now, as of now, the election process has started.
Yes, Your Lordship.
Now, Mr. Joshua, what do you say about this Constitution Bench judgment in Lakshmi Sharan Sen versus AKM Hassan Uzman, wherein it says that the elections are to be held on the basis of the existing revision as on the date of the notification of the. You cannot touch that.
No, my lord. May I take your lordship to section 37 of the main act and the rule 6?
No,
What
no,
my,
no, no,
yes,
no.
your lordship.
Mr. Joshua, I understand everything. They have made a lot of illegalities. But you have to also consider that elections, once the election process has been notified, then under such circumstances, the court's power or the court should not, taking into account the overall public interest. As of now, today is 7th is the last date of filing nominations.
Beginning, 7th to 11th, the filing of
Nominations,
nomination.
but the election process have already started. So under such circumstances, can it be done in view of this judgment? 85-4 SCC 689.
No, my lord, may kindly appreciate this. The facts and circumstances of that particular case in this case is totally
The
different.
issue
Yes, your lord.
involved in, see that it is not the question of facts, it is a question of whether the question which was referred to the Constitution Bench was very specific. That once an election process has started, can there be any intermeddling with the electoral rules?
My lord, may kindly appreciate this. Here is a case where the voter was not aware. They have mentioned in their document which has been placed before your lordship now, that it was notified. Notified to whom? Few individuals, the ward officials.
It was notified to the Deputy Commissioner. It was notified to the EAC, all ward chairmen, all presidents, political parties for information, MIS, JTC for information and attendance, office copy.
Then let us go to the rule 6, your lordship. How it is to be notified so that the voter will know whether his or her name is there or not. Rule 6, my lord.
Rule 6 clause.
Now,
2.
lordship, it has to be kept advertised. I mean, it has to be in the notice of
Understood,
the
Mr.
voters
Joshua,
in all such necessary places.
I understand everything.
My lord.
Let us assume that they are wrong. Let's assume that they are wrong. They have not done it.
My lord.
Can it be at the behest of some individuals? An election process can be installed. Because as of now, there will be that would amount to revision of the rules.
My lordship, there are
although the
only
bar
very few people before this honorable court.
329B would not come because revision of electoral rules have been held by another constitution bench. In the case of Indrajit Borwa, that look here, that is not a part of the election. So under such circumstances, that is nothing to do with the elections. Therefore, a revision, the question before the Supreme Court in that constitution bench was that if the revision of the electoral rules have not been done properly, can there be a question of challenging the election petition by way of her? The Supreme Court said no, you cannot, because it is not mandated in terms of section 81 of the Representation of Peoples. So under such circumstances, as of today, can we say to the effect that this modification can be made now?
No, your lordship, the section 37, as far as the state of Nagaland is concerned, of the Municipal Act of 2023, till the period when the nomination period is yet to be concluded, section 37, your lordship.
Any person whose name is not included in a word may apply to the electorate for inclusion of his or none. The electorate shall, if satisfied, the applicant is entitled to be registered in the net directory. When applicant is registered in the law on any of the information form, the electoral registration officer of the other words in a no transposition or deletion of any entry shall be made under section 36. And no direction for inclusion of name in the shall be given under this section after the
So it is up to the last date of making nominations, Your Lordship.
So you moved the ERO. You moved an ERO.
Yes, Your Lordship, we have already submitted our application before the returning officer for inclusion of our name, because here the circumstance of the case is that the voter was completely in the dark, Your Lordship. If the voter was by some means that he was aware that his name is not there, especially an intending candidate. An intending candidate kept in the dark, Your Lordship, this is a very serious infringement of the rights of the petitioners, Your Lordship.
Yes, Mr. Additional Advocate General, what do you have to say on that?
Yeah, Your Lordship, here the fact of the case is such that respondent petitioner, all the petitioners, they have submitted their application to Colony GB.
To the?
Colony GB, Kampura.
Hmm.
And the rules 13, 14 says 13, inclusion of names in the rule finally published. And 14, the manner for making application for correction of interest and inclusion of name in the rule. It is clearly said, but here in this petition, all the three petitioners, they have submitted, if they are really independent candidate, and way back in 2022, they have submitted to the Kampura. But the rule.
No, they have submitted to the returning officer.
No, Kampura in the petition they have given to the Kampura, Colony Kampura.
Where? Let's come to annexure I, page 34.
This is application might be, this is about the annexure 1 is a complaint, Your Lordship. But I mean, I'm reiterating about the dear application for enrollment to enroll into to include in the hero.
What we have said it in our petition is that it was submitted through the Ganboro, Your Lordship. The
Yes,
Ganboro is not the
yes.
authority. So it is through the Ganboro, and then it is the state respondents who have authorized the ward chairmen, the GBs to collect on their behalf to be submitted to the state authorities. There's nothing wrong with that, Your Lordship.
Your Lordship, whatever may be through home, that is another way. But they have submitted way back in 2022, where the municipal act was, it was under 2001, and it is already repealed, and for which the notification was issued on 4th March 2024, on amendment of the enactment of the new act and rules. So if I'm just talking on the merit of the case, if the petitioners are determined to be a candidate, then they should be aware that is a number one duty of the any citizen, or particularly, more particularly the intending candidate. So the role is very clear. It is a petitioner. They are not sincere enough. They are not diligently checking the notification
No,
issue by the
it is
election
okay.
commission.
But how do you take care of Rule 37?
Section 37.
Rule, Section 37. How do you take-
37, if they are aggrieved, then they have another remedy, alternative remedy.
But now also you can do it.
Yeah, but you see that is, there is no fault on the part of the authority. It is a petitioner, and they should be diligently enough if they really determined to contest in the upcoming election. So I'm going to the petition and I'm going to the merit of the case. So they were not diligent enough. So at the last hour, they are just pumping on the election commission.
They
So-
only file it on 23rd of May
23rd May.
and then file the resolution when? On 28th of May. Filing the resolution on 27th of May.
Now, Your Lordship, the provision of blue is another question. But here, in this particular case, in the state of Nagaland, regarding this ULB election, There's a direction from Honorable Supreme Court.
When was the final list published?
Your Lordship, depends on places. In Dimapur 1, according to my client in the case which was filed this morning, Your Lordship, I came to know on 29th May, Your Lordship. It was final list was published only on 29th May, Your Lordship.
Where have you mentioned in this thing when, how did you come to know your name was not included?
As far as the motion item number 1 and 2 are concerned, Your Lordship, they came to know about the final list on 13th May, Your Lordship.
Where?
It is,
Where have you mentioned?
Lordship, it is mentioned in the petition as well as in the synopsis as well.
No, petition where? Petitioner, paragraph 7.
Yes, Your Lordship.
So in these 1 and 2, it has been published prior to 13th May.
That we do not know, Your Lordship, because
Obviously, you get to
yes,
know
Your Lordship.
13th May.
Yes, Your
So
Lordship.
it has to be prior to that.
If we are to go by the Rule 6, then, Your Lordship, it has to be widely notified. In this present scenario, Your Lordship, will kindly appreciate this in all the municipal councils in different districts. It was never publicized to the extent that a voter or an intending candidate came to know that, oh, my name is there, my name is not there. Only after the period, the window period opened for the voters that they can complain. It's only in the month of May itself that they came to learn that their name is not there, and by then the window period which was opened is already closed. Whereas they never came across the draft roll, which would enable them the opportunity to be able to approach the authorities that their names are not included, Your Lordship. So, Your Lordship, the provision of Section 37, as my Lord has already seen, this opportunity, an exceptional relief in a situation where no fault is attributable to the candidate, with due respect to my learned senior colleague for the state, Your Lordship, that submission is not acceptable at all. How can the state not take responsibility for the mistake that they have created themselves? And if they say that they have started the process of enumeration by 4th March, is it humanly possible to even conclude, Your Lordship? After 2-3 months also, it would not be complete to start the enumeration by 4th March, Your Lordship. So, my Lord, here is
Your name is in which town committee?
the petitioner number 1 and 2, Your Lordship. I mean, item number 1 and 2, Zineboto Town Council, as well as item 38, Zineboto Town Council. Item 43, Dimapur 1 constituency, Your Lordship. And there are many who have not approached this Honorable Court. But so many names have been left out without the voter even knowing that their names are not there in the electoral roll for the ULB elections, Your Lordship.
But all the petitioners have their names.
Yes, Your Lordship. In the assembly constituency for that particular area.
Houses.
Yes, Your Lordship.
House number which is there is within that council.
My Lord.
Town council.
Yes, Your Lordship. Assembly constituency, parliamentary assembly elections, which was recently held, also they're all there. They have participated in the elections, and they were not aware that their names are not included here in the e-roll for the ULB elections, for the municipal elections, Your Lordship. And my Lord, not for the sake of argument, but for your Lordship's knowledge, some of these petitioners have a very good chance, even to the extent of getting uncontested in the upcoming ULB elections, Your Lordship. It's very unfortunate that a petitioner would not be made known of whether his or her name is in the list, because the list was never shown to the public, Your Lordship.
Where have you published this one, the Form 2?
Lordship,
Where have you published Form 2? You have given 2 documents today, 3
Yes.
documents. Where have you published Form 2?
Your Lordship, here, as per the provision, we just publish in the office.
Hmm?
ARO, Deputy Commissioner Office and Electoral Registration Office.
But it is not shown where you have published. Like earlier, the circular is made copy to various offices.
Yes.
But where have you published this notice for
No,
publication?
it was actually, it was not a publication in the media, but it was hanged in the office.
How do you know? It is to be hanged in the notice.
And particularly this ward number, regarding the election to the Zanabatu district, it was communicated and in the ARO has invited all the stakeholders.
Understood. You invited the stakeholders via circle notice on 8th.
Yes,
On 8th only these stakeholders were very much present.
yes.
Then how will the other people get notice?
No, your Lordship, here in Nagaland, our society system is such. If we can just pick up the ringleader, then it is easily to spread the information. So in one way, even though it was not published in the local media, but they have contacted all the ward members, Kambura.
No, that is also not there. Here it is not mentioned out there to that effect.
No.
The second page does not say. Like the first page,
Yeah, first page.
categorically says that on these to all these people, copy
Yes,
to all these
yes,
people.
it is.
Where does this notice say that it is a copy to anybody? This
No,
is given to the electors of the constituency. Where we
Yeah,
publish.
so it was all inclusive. All page number 1 and 2 are one set.
No, it can't be. Because page number 1 is of 4th.
So
and page number 2 is 8. That means, are you saying that page number 4?
Sorry.
You can't say that.
Lordship, yes. It is hang up in the notice board.
Huh?
Notice board.
What?
In the notice board of the ARO and Deputy Commissioner.
All are of the same town council.
Yes.
The 3 petitioners, Your Lordship, item number 1, 2, and 38, Zinevoto Town Council, different wards. Item number 2 and 38 are ward number 10. Item number 1 is ward number 11. And the petitioner in item number 43 filed this morning, the Lordship is of Dimapur 1.
Dimapur?
Dimapur 1. These are all intending candidates, Your Lordship.
Dimapur 2, obviously, I can't take it up today because he has no instructions for that.
No, Your Lordship.
43 is different. There is no notice issued. I can very well take this and the other one if it is of the same June Boto Town Council. I can take it up. But for Dimapur, this board is not in a position.
I have to take
do that,
instruction.
because without issuing them a notice, a minimum asking them that what do you have to say on this, I can't.
Lordship is similarly situated.
So what?
My Lord.
That is Dimapur. You want to vote it out there in Dimapur?
My Lord.
You ask for the number 43 to go to Zunbeto.
My Lord will kindly consider this aspect.
Not, I can't.
The party tickets are to be issued tomorrow and day after tomorrow, my Lord.
Don't contest. Contest next time.
My Lord,
You woke up
no,
so
if
late.
my Lord will kindly appreciate this, if the fault is attributable to the candidate, then your Lordship, what my Lord says is fully correct. But here is a case where the person who is intending to contest and he is even having a very good chance of winning is not aware that his or her name is not in the electoral roll, just because the authorities have never made available. For the sake of argument, just not to argue, I'm not responding to my learned senior colleague's submission that it was published in the offices. It was nowhere, Your Lordship. It's a fact, Your Lordship. It was nowhere published that the voters would be able to see that, oh, my name is there, my name is not there. It should at least, that opportunity under Rule 6 has to be made available to the The petitioners, your lordship, it was never made, your lordship.
They will go home to your place and publish it. It is always hanged somewhere. This is how it works.
So, your lordship, when the petitioners are not aware that their names are not there.
You are not diligent. You must
No,
have now got it.
that point, your
Now
lordship.
I will win it because of this election results out here in the union. Out there now I have a fair chance. You are of some party? No party.
That's not the case, your lordship.
Are you of some party or not?
Yes, some of us are going to get tickets, your lordship, in different parties.
Tickets of which party?
Leaving that aspect, my lord will kindly
Basic
appreciate.
question
Yes.
is this, na? I am given the ticket in somewhere.
So, your lordship, my lord will kindly appreciate section 37, which I need not stress further because my lord is fully aware that even assuming that there is a clash between the rule and the act, the rule is subservient to the parent act. Here, of course, there is no clash as such. But my lord, since
No. Section 7 gives you a way.
Yes, your lord.
In the circumstance, rule is
No clash, your lord. Yes, your lord.
Section 37 is before the final date of publication. Section 37.
Yes, your lord.
But postulates a particular manner in which they have not
My
done
lord.
it, they can still rectify in the 37 till then.
Now, my lord will kindly appreciate this aspect. When all the petitioners, since
So you were going to get uncontested. And have to write down your submission. Your submission.
your lordship, my lord may kindly, to that extent, if my lord does not question me, I will be very grateful because party tickets are to be issued
Again, you are coming back to party tickets.
in the next 2 days. So all the parties,
Which party?
all the parties, your lordship,
Parties,
all the political
different
parties.
Allah,
Now,
different parties.
different political parties are going to issue tickets. And in Nagaland, the parties which are active are the NDPP, the BJP, the LJP, the NPP. So for NPF, these are the political parties who will be issuing the tickets also, your lordship. So, my lord, when they are squarely covered by section 37, and I would appreciate if the state would also using the service of the additional advocate general. I wish they can also be honest because the fact is, this is not a trial court, your lordship, which I know there is a limitation of my submission also before the December court, but they have to be honest also that they have not published anywhere. No voter was aware whether their name is there or not. I'm a voter here in Kohima. Your lordship, at no point of time that no such draft roll was published that we were also aware. Thankfully, my name is there, your lordship. But my lord, there is a case that it was never notified to the public, your lordship. So in that case, when there is no fault attributable, your lordship, section 37, the provision, my lord, when the case is squarely covered by section 37, it is my sincere and humble request to this honorable court that the matters may kindly be disposed of today, including item 43 also, my lord. There's no such thing.
Your lordship,
This end, this time, get the petition.
Yes.
That too, when I am again sitting in division bench on Wednesday, it has no alternative.
then in that case, your lordship, then is it a already or it is a petitioner? Why they come for the BBC? And see, go by this, the BBC, it's very infringement. So all the videos, the lens included, all it is. No. And you're not-
But it's an application in time. Your basic contention is like this. We have published the draft notes and therefore we take time to 23 to say make any complaint. And as such, now they cannot educate this estate. That's your submission. That is your pitch. Whereas, you should have said that you can. I need people to learn how to do what the final rules. And when you if that is so, it's not that asking for the last occasion by its own notice. Okay, what are your instructions? The instructions that on 8 on 6, we have issued a notice. Report. We have issued a notice fixing it on 7. On 6, we have issued a notice to all people concerned members, fixing it on 7. Then on 7, I don't know what happened. On 8, we issued a notice on that day where they have to have it. So where we issued a notice? We have not issued the notice properly. Otherwise, in view of the Constitution bench judgment, this court could not have done. But in view of the exception which has been drawn out in section 37, you can still do it if it is on the apparent favor of your do it.
Yes, sir.
But not for
But when there is no and there is a submission, then the remedy is there.
where will you go? You give an undertaking. You give an undertaking that you will consider. You give an undertaking that they will you say that they have an alternative remedy. You give an undertaking that you will consider by tomorrow. Give an undertaking. That you can't. That is why there is no alternative remedy. I'm not asking you to give it. I'm going to ask you an undertaking that you consider, which you would say your basic stand is, okay, we are not going to consider because you the fact that whether you have published it or not, I would have otherwise not touched it because the Constitution bench judgment is very clear. Here it is. The three with petition heard Mr. J. Seki, the learned counsel, appearing on behalf of the petitioner. This is 43. 43, not 4. The learned counsel appearing on behalf of the petitioner in the three with petitions, and Mr. Song, the learned listener, appearing on behalf of the respondents in the in the three with petitions, the petitioners being agreed by their non-inclusion of their names in the electoral roll of the ward number.
Your Lordship, item number 1.
All these are which are wards.
Ward number 11 and 2 petitioners in ward number 10.
Then
2 petitioners are ward number 10, 1 petitioner ward number 11.
Non-inclusion of their names in the words of Zunhe Boto, Town Council, and upon submitting representation and not receiving a favorable result, have approached this court by filing the petitioner in WPC number 87/2024 admittedly is a citizen of India. And his name is, is reflected in the assembly at serial number 83 of the electoral roll of the assembly constituency number 30 assembly constituency number 35 Dunheve 2. South Point, South Wing of section number and name 1 South Point, South Wing. The petitioner in WPC number 88 of the 2024 is also a citizen of India, and his name, her name appears at serial number 672 of which assembly constituency?
35 assembly constituencies.
Section
DC
name?
Hill, DC Hill West Colony. Lordship election B. That copy is at page 20. Lordship, the last part, my lord, comes to the bottom. Place DC Hill West Zenobito.
What is that section name? Of section number and name. Number is what?
The assembly constituency number or the house number, your lordship?
No, section name.
Ward, the ward, DC
No.
Hill.
Section name.
E-roll number, your lordship, 672.
Of DC Hill, bracket west. Huh? The writ petitioner in WPC number 90 of 2024 is also a citizen of India, and his name, he's not her name appears at serial number 104 of the assembly constituency number and name 35 Zunavito, section number and name 1 Natha Old. Good stuff.
My lord, my sincere apologies. In 90, there is a typographic here. It is Natha Old, not DC Hill. Natha Old.
Natha.
Natha, Natha. Natha. Natha Old.
Natha Old. One. So that section number will be same, na? Section number and name. Agor to juntu ase, major to 88. 88 যোনটো আছে of so and so.
The serial number 105.
30 assembly constitution number and name 35 Junebitu, section number and name 1 Nata old. Huh? The petitioner number 1, the petitioner in WPC number 87 claims that he is a resident of ward number 11.
My lord.
Whereas the other two petitioners claim that they are residents of ward number 10
My lord.
of Zunavado Municipal Council.
Town council.
Town council. In terms of the Nagaland Municipal Act 2001, certain revision of the electoral roll, certain steps for revision of the electoral rolls were conducted. And in that regard, the petitioners herein claimed that they had duly submitted their applications as per the requirement. However, on 13th of May 2024, all the petitioners,
Yes, your lordship, as far as Zinaboto is concerned.
all the petitioners came to learn on 13th of May.
Yes, my lord.
On 13th of May 2024, the three petitioners came to learn that their names were not included in the electoral rolls of the Junebato, what is that? Town council.
My lord.
Under such circumstances, the petitioners submitted representations
My lord, the petitioners in 87 and 88 submitted on 20th May, May 20.
submitted representations on 25 2025 24 25 2024 and 20
and 25/5
25
yes my lord
25/5 2024 for correcting the for including their name in the electoral rules. However, the same having not been done, and there being an there being urgency in view of the impending elections to the town councils.
Yes, your lordship.
Duly notified by the notification dated (26th of April 2024). The petitioners, the three petitioners filed separate petitions seeking directions for including the names of the petitioners in the electoral rolls. For twit. In addition to that, the petitioners have also challenged the notification dated 4th of March 2024 on the ground issued by the State Election Commission of Nagaland on the ground that without due compliance to Rule 6 of the Nagaland Municipal Election Rules 2023, the final rolls, electoral rolls were prepared. And as such, the said notification is non-est. Pursuant to the filing of the writ petition, this court, by an order dated 28/5/2024, directed the learned Additional Advocate General Nagaland to obtain instructions for invoking the powers under Section 37 of the Nagaland Municipal Act 2023, for short the Act of 2023, and considering the representations of the petitions. It is under such circumstances the three writ petitions have been listed before this court today for motion. This court duly takes note of the notification dated 26/4/2024, whereby the election schedule have been published. And taking into account the same, this court is of the opinion that the three writ petitions are required to be taken up for final disposal at the motion stage. This court have heard Mr. J. Siki, the learned counsel appearing on behalf of the petitioner, submits that there has been no compliance in terms with Rule 6 of the Nagaland Municipal Election Rules 2023, for short the Rules of 2023. Inasmuch as there was no adequate publication of the draft rules.
Rules.
The learned counsel submits that as per his instructions, there has been no draft rules at all. He further submits that unless and until the aspect that the draft rules have been published is not widely circulated, the electors, like the petitioners, would not be in a position to avail the remedies in terms with Rule 7 of the rules of 2023. Further to that, the learned counsel submits that section 37, a reading of section 37 of the Act of 2023 would show that there can be inclusion of names in the electoral rolls till the last date for making nominations for any elections. Inasmuch as section 37(3) categorically observes, stipulates that only after the last date for making nominations for an election in that ward and before completion of that election, there cannot be any further insertion or deletion in the electoral rolls. Anything else?
That's it, my lord.
The learned additional advocate general submitted that the representation so submitted by the petitioners have been duly rejected, taking into account that they did not take steps for submission of for seeking correction or insertion of their name within their time stipulated in terms with the notification dated 4/3/2024. He further submitted that the petitioners have been negligent and as such, and the petitioner have not been due diligent, and as such, the petitioners are not entitled to the relief so sought for. When the matter was taken up in the first half of the day, this court sought for an instruction as to when the draft rules were published and in what manner. In the second half, after recess, the learned additional advocate general placed before this court 3 documents which are marked collectively, which are marked as annexure X, Y, and Z. Annexure, the document marked with the letter X is a circular issued by the administrator and ERO, Junheveto Town Council, wherein it was mentioned that the special summary revision of the electoral roll for Junheveto Town Council will commence from 8th of March 2024. And as such, all concerned members were informed to attend the meeting scheduled on 7th of March 2024 at 1 p.m. at Junheveto Town Council office. This document also shows that the said circular was marked to the Office of the Deputy Commissioner, Junheveto, Nagaland, for information, the EAC and AERO, JTC, Nagaland, all ward chairmen / GBs for information and attendance, all presidents, political parties for information and attendance, comma, comma need to semicolon. MIS ZTC for information and attendance, and one for the office copy. The document marked with the letter Y is a notice of publication of the electoral draft rolls in draft. Wherein it has been mentioned, that any claim for inclusion of the name in the roll or any objection to the inclusion of a name or any objection to particulars in any entry should be lodged on or before 23/2024 in form Roman 3, Roman 4 and 5 as may be appropriate. It was also mentioned that every such claim or objection should either be presented in the office of the electoral registration officer or to the EAC and Assistant Electoral Registration Officer Junebetu, or sent by post to the address given below so as to reach not later than the aforesaid date. The document marked with the letter Z is a document pertaining to the joint meeting in terms with the letter for summary revision, which was held on 8th of March 2024. The letter which have been referred to is the document which have been kept on record and marked with the letter X. This is a different letter. Joint meeting as per letter dated SCC MTC SR1 24 March. It is a different letter. Exhibit Z, and a document marked with the letter Z, is a document which shows that there was a joint meeting in terms with a letter number SCC/MTC/SR-1/2024 for summary revision of Zunebeto Town Council on 8th of March 2024. However, the said letter number SCC/MTC/SR-1/2024 have not been placed before this court. In addition to that, the learned additional Advocate General further submitted that the petitioners, having not availed the remedies as available under the Act or the rules, Act of 2023 or the rules of 2023, the petitioner is not entitled to the relief as has been sought for. In addition, further to that, the Learned Counsel also submitted that the petitioner has an alternative remedy. You have. In the backdrop of the above submissions, so made by the Learned Counsels for the parties which have been duly given due consideration, this court takes up the instant proceedings for this. In the backdrop of the above contentions which have been submitted, let this court decide as to whether the petitioner in the instant case can be granted, can be decide as to whether the petitioners herein are entitled to the relief as regards inclusion of their name in the electoral rolls of Junevetu Town Council. In the previous segments of the instant judgment, this court have duly noted that the petitioners' names are duly included in the
E-roll of the
assembly in the electoral rolls prepared under the Representation of People's Act 1950 in respect to 35 number Junevetu constituency, Legislative Assembly constituency.
Yes, Your Lordship.
It is seen that the petitioners have claimed that only on 13th of May they came to learn, 2024, that they had come to learn about the exclusion of their names in the electoral rolls. Before further proceeding, this court finds it very pertinent to take note of Part 2 of the rules of 2023, which is in relation to registration of electors. Rule 4 stipulates the disqualification for registration in a rule It is seen from a reading of the said rule that a person shall be disqualified for registration if A, he is not a citizen of she is not a citizen of India, or B, he or she is of unsound mind and stands so declared by a competent court, semicolon, or C, he or she is for the time being disqualified for voting under the laws relating to corrupt practices and other offences in connection with the elections, including parliamentary and state elections, semicolon, and D, he is less than 18 years of age on the qualifying date. The qualifying date have been explained in the said rule to be the first day of January of the year in which it is so prepared or revised. The fact that the petitioners herein have their names already included in the electoral rolls of the Junevetu Legislative Assembly constituency, it is apparent that the petitioners do not have any disqualification for being registered as in the roll. Rule 5 stipulates as regards preparation of the electoral rolls. Rule 5.4 stipulates that a notification to be published in terms with Rule 5.3, apart from being published in the official gazette, shall also be affixed in a conspicuous place of the office of the Deputy Commissioner of the district and such other places as the government may specify. Rule 5.5 is of relevance taking into account the dispute involved. It stipulates that for the purpose of preparation of the roll, the electoral registration officer may send letters of request in Form 1 to the occupants of the dwelling houses in the constituency or any part thereof, and every person receiving any such letter shall furnish the information called for therein to the best of his or her ability. Yes, Mr. Joshua, I asked you to find about down below the next one. Did you find out during the recess? That is a very relevant thing. His brother's name is there. Did you find out? 83 is this. 86. Page 17 of your petition. Did you find out? Please do. That is a very important aspect because his brother's name is there, which also shows this. This is a very important issue. Huh? Just find out. Rule 6 stipulates publication of the draft roll. The same rule 6 having being of paramount importance for the purpose of adjudication of the instant dispute is reproduced hereunder. A perusal of Rule 6.1 stipulates that the electoral registration officer shall publish a draft roll on such date which is not later than the date given in the program notified by the Commission. With a notice in Form Roman 2 intimating the date by which claims or objections with regard to the roll may be presented to the electoral registration officer or such other officer as may be authorized by him or her and specified therein. Rule 6.2 stipulates that a copy of the roll of each constituency shall be affixed by the electoral registration officer at Roman 1 at the office of the electoral registration officer, Roman 2 at the concerned municipal office bracket S, Roman 3 at such other place in the concerned municipal officer area as he or she thinks fit. In addition to that, the electoral registration officer may further take steps in any other manner as he or she may think fit in order to give its wide publicity. Wide publicity, bold and underline. First. In the backdrop of the above rule, let this court now into consideration the document marked with the letter Y. A perusal of the said document marked with the letter Y says that a copy of the said draft rules is available for inspection at the office of the Electoral Registration Officer, Zunavatu Town Council, and at Zunavatu Town Council office. However, it seems that the Electoral Registration Officer did not take steps or exercise his discretion in terms with clause rule 6.2 Roman 3. There was also no attempt being made as nothing has been brought on record in spite of notice being issued on 28/5/2024, that there was any steps taken by the concerned ERO in terms with clause 6.2 Roman 3. First, this court now finds it very pertinent to take note of Rule 7, which stipulates the manner of making and lodging claims and objections. But the question arises as to how the question arises as to whether Rule 7 can deprive a elector of his right for inclusion if there is no wide publicity, which is the intention behind Rule 6.2 Roman 3. This aspect of the matter assumes importance, taking into account that it is the specific stand of the respondents that as the petitioners did not avail their remedies in due time, they cannot now agitate the same by filing representations or filing the instant petition. As already stated here in above, Rule 6 bracket 2 conceives of that there shall be wide publication. This concept of wide publication is being done. The concept the said rules concedes of wide publication in order to, so that the respondents, so that the electors are in the best position to lodge their claims and counter claims as regards in terms of Rule 7. But since wide publicity, it may not be known to the electors that they are required to take steps in terms with Rule 7. Now, tell me whether this notification was published in the Gazette, page Annexure C. Page 23. Was it published in the Gazette?
As far as my knowledge goes, no, Your Lordship.
No, it should be published in Nagaland Gazette. Because this notification was issued to many departments. Did you have notice of this?
No, Your Lordship.
Then whether you are diligent. Because there you have the date.
Serial number 19 is active.
Hmm?
Serial number 19.
What?
No, my lord. Even if, assuming that my clients have seen this notification, until and unless the role, the draft role.
Forget about the role. You should have, did you inquire as per this? Did you inquire?
My lord, it is assumed that every name is.
There's no assuming. When this notification was very much there saying that on draft roll will be published on 8. Did you inquire? Period for lodging the claims and objection is from 11 to 20, which is as per that form 2. Did you inquire?
As far as my instruction goes, my lord, the clients have been checking the State Election Commission website constantly. But after 2021, there has not been no update, Your Lordship, in the State Election.
You want to contest an election.
No, no.
So you have to be more interested. This is a case of diligence. How do you take care of this? Think. If you have not done this, have you stated that you have no notice about this notification? If you have not, where is the diligence? Because this is otherwise informed.
As far as the petition is concerned,
did you say that we had no notice about this notification?
Please, Your Lordship.
Hmm.
Lordship, I was not anticipating this question from the Lordship. However, if my, what may kindly appreciate this fact, as far as all these notifications are concerned, I sent my juniors to different offices to get the notifications. When it comes to my client, the Lordship, he was not aware of any of these notifications.
It can't be.
No, I collected.
No, then obviously he is not interested. He's not interested. You cannot come like that. You cannot come like that. Because you did not say about this notification.
Fourth March notification, the 26th April notification, and the May 20 notification. These are the three notifications I got it from the election office.
No, this notification was very much there in the website. Isn't it?
The website?
This notification will be.
No,
updated.
Your Lordship, website has not been updated after May 20, after 2021, Your Lordship.
No, but this notification was very much there.
May I be allowed to present the copy to Your Lordship to show that when the last update was made?
No, not necessary. This one, this notification. You have not stated that you did not know this notification. Where is your statement in your petition saying that in view of this notification, you inquired and found that there was no draft rules? Is there any
No.
statement to that effect?
Do we have to go into that detail where?
Yes.
Is Your Lordship?
No, this is not a small thing. It's not a small thing. There is an entire exercise. This is going to open. Yes. Otherwise, it's a different thing. But when there is a notification to that effect, categorically mentioning, I would have understood. He has not published it on 8th. He has done it on some other date. He has done it on some other date. Then it's a different thing. But he has published it on 8th. That is as per the notification. Till 20, he has given time, which is as per the notification. You are not there. How do I help you?
Your Lordship, if you are going to all those nitty-gritties, Your Lordship.
That
to the
is
details,
nitty-gritties
then
is there.
No petitioner coming before this Home Court will get any relief, my lord.
Can't
Because
help it. No person comes
Your
with it
Lordship,
very well.
when somebody is preparing for an election and the list is not made.
And somebody is preparing for the elections, he will be more than diligent for that. Will be more than diligent to do this. You were interested, wouldn't you be interested about the electoral rules?
When it was not made known to the public, Your Lordship.
It is
and it was
made,
not published.
it was very much published. You see, as per Rule 6, where are the two things it is required? It is there in the municipal office. It is there in the ERO's office. You didn't go there.
Your
As per
Lordship,
Rule,
the draft roll was never published.
it is there in the electoral office. You could have gone there.
This is the final list which they have annexed that the copy is presented before Your Lordship. This is not a draft copy which they let them show the draft roll which they published then, Your Lordship. Because Your Lordship, the dismissal of this petition is going to have far-reaching consequences. Your Lord. So let him show by way of the document, the draft roll, This is the final roll they have prepared. They have shown before Your Lordship this afternoon. Let them show the draft roll. My Lord, then I will concede defeat, Your Lordship.
You have the draft roll?
2024, 22. They have only shown the final list, Your Lordship, not the draft roll. Let them show the draft roll, man. Notice the pictures and names are shown, followed by the circular dated 6 March 2024. Page 1 to 30.
What was the number of that person? The 87?
In the
serial list?
83 in the State Assembly constituency electoral roll, Your Lordship, was voted down.
Yes. South Point, what was the number?
South Point East, house number 120.
No, no, no. What was the serial number?
This serial number was 83, my lord.
83 is, what is his name? Hobi.
Oh, Heto.
Huh?
His name is Heto. So his name is not in this list, Your Lordship. This is the final list, which the state is present for Your Lordship.
This is the final rule.
This is the final rule, Your Lordship.
I told to bring a draft motion. I think we have.
And in the second petition, what is his house number?
Lordship,
Second petition, what is the house number?
house number 88,
Of DC Hills.
DC Hills, Your Lordship.
It is not there.
Seven and 88, both houses have been skipped.
120 is also not there. Let's check out who is 120A. There is another house, 120B.
120B.
In the first writ petition 87. 120B is there. Okay, just put out 119. 119. What is his name? Mr. Joshua, you are too take a lot of time.
The Lordship is on writ petition number 87.
87. Who is 119? No, actually, this is the, you see, you are saying, nah, these are the two. It is the first one is the draft only, which has been made final.
2022 is a draft roll and 2024 is a final.
Hmm?
2022 is a draft roll,
Lordship,
24 is
my
a final roll.
He is contradicting himself. According to his submission for the new act, the Lordship, the exercise began only after 2023. So where is the picture of 2022? Then I can go back to my petition at paragraph 9 and argue that I have given all the documents to the authorities.
One 120 is which one? This is which constituency? East, west.
Lordship, according to the notification dated 4th March 2024, draft roll publication of electoral roll 8 March 2024. So how can my learned friend go back to 2022?
No, it's okay, but how do you take care of that? This notification, 4th of March.
Now, my lord, the question is also, my lord, may kindly consider this aspect. Have some consideration for the petitioners also. My lord, whether the draft roll was ever published.
By the time we find out, your period is over.
My lord, it can be made available even tomorrow morning also, your lordship. The office is just here. If they are not going to prepare a manufacturer document now, it should be available, your lordship.
Worship, draft roll doesn't say publication. Section 3.
No,
Section
publication
6.
of electoral roll.
Electoral roll, draft roll.
Publication.
It has to be kept in the ARO office, Deputy Commissioner office. And it is already there. It is already there in the section 6.
We go back to section 5 again.
No,
Rule
publication.
5 again.
Draft roll as a wing with a detail about the draft roll. It has to be, normally it has to hang in there from the Deputy Commissioner office, who is a returning officer or ARO. So it is clearly mentioned in section 6, publication of draft roll. It is already done. We have already,
My lord, may,
we have already crossed this actually.
if my lord may kindly give an exception to this urgent matter to avoid any manufacturing by the authorities, which happens everywhere, my lord, when they are caught. Office is nearby. Let them bring it in 1 hour, my lord. So that's a sincere request that I'm placing before your lordship, because this is a question of a future of a person, your lordship. My lord may kindly consider the aspect. Let them, they have only produced before your lordship the final copy, not the draft copy, which they have already published on 8 March, according to their claims, according to the document. Let them produce it, my lord. I think your lordship should
Section
make an exception.
3, clause 2 is very clear about this. A copy of rule of each constituency that is about the draft ruler shall be affixed by the electoral registration officer at the following places. So we have already crossed this, your lordship. So draft copy, not publication, but it has to be displayed before such prescribed places.
My lord, there should be no apprehension on the part of the state to produce that before your lordship.
Now we have all document the petitioner.
So let them
all
produce the
submission.
draft copy, your
That is
lordship.
a mere
The draft
submission
vote.
only. Since is being agreed means deprive of all this opportunity because of his negligence.
Lord may also kindly appreciate this, which my Lord has fully understood. But Rule 37, there is no ambiguity. Section 37 of the Act, my Lord.
Last time to kill. This court also takes note of the notification dated 4th of March 2024, wherein various dates have been mentioned. The same notification is in terms with Rule 5. The petitioners state in their petitions that they had neither knowledge of the notification dated 4th of they had neither knowledge about the notification dated 4th of March 2024, nor were informed by the Colony GB oblique the ward chairman oblique the enumerator, who were directly in touch with the authorities about his name not being included in the voters list.
I beg your apologies, Your Lordship. I've stated at paragraph 12 of my petition.
That is what I read it. During the course of the hearing, the learned Additional Advocate General submitted two sets of electoral rolls. One is of the year 2022 and the other is of the year 2024. In the entire set of the documents which have been placed as relating to the electoral roll of 2022, it is seen that were various additions being carried out pursuant to the publication of the draft rules. For example, in respect to ward number 10, ward number 10 DC Hill West, three electors were added, 3 male electors were added, and 5 female electors were added. By coming up with a supplement electoral rule. Now, if you say that there was no inclusion, there was no draft rules, how are these supplementary thing had happened in 2024 also? Original role had in this your ward named South Point East. Originally, it had 629. There was an addition by one female voter, which made it 630. How did it happen if there was no draft rules?
Your Lordship,
The petitioner was
that
not aware.
I have no reply. Because my Lord,
Issues the petitioner is
No,
not
no.
aware. Others are included.
You are not
Only the
aware.
petitioner.
How do I help you?
then my Lord, then in that case, the Honorable Court will have to come upon the representatives of the state respondents. They are the ones who have.
Then if you want so much, I'll ask them to file an affidavit. We'll give him 1 week's time to file an affidavit. There's no way out. If you're asking so much.
Oh, my Lord.
You
That's just a
see,
matter of
you are
submission. If not,
put
my
this-
Lord is fully aware. All I want is my name to be included. my
How
Lord.
do I, you see, it is, this is not going to be, this will have a far-reaching consequences every time a person comes.
My Lord,
There
here
is a
the
limit everywhere.
Clear discrepancy on the part of the state respondents is
That
very
is
clear.
why
my
you
Lord.
have this system. You were a sleeping duck. How do I help it? And all 3 petitioners from 3 different words come to know on 13th.
That's because it was made available to them on that day, my Lord.
How is it possible when the final rules were published on 12/4?
That's why, Your Lordship.
Are you
Now,
saying that the final rules were not published on 12/4? Final rules were published on 12/4.
that is the claim of the state respondents.
That
Your
is not
Lordship.
the claim of the say. It is already there on 12/4.
So how can this Honorable Court say, if we have to see the other way around, my Lord, whether the date is the actual truth? Because, Your Lordship, until and unless the voter comes to know
Then I
the
think
list made available to him, how will he know that?
best is for the civil court to decide.
Oh, my Lord, to avoid that, I'm begging Your Lordship to kindly invoke the provision of Section 37 of the Act.
Understood. Section
Yes, Your Lordship.
37, I would have done it. But how do you take care of this? There has been a supplementary list. How do you take care
Now,
of
whether there be any supplementary list or not, my Lord, till the filing of the nomination, my Lord has rightfully observed. So, my Lord, kindly give me the benefit so that I can also fairly contest in a democratic election. my
Mr.
Lord.
Zaki, kindly understand, if I open up this thing, every time this is not this time, this is This order will be a precedent for all time to
Yes,
come.
how is it
How do I take care of that? Tell me. One has to consider that.
No, I have understood, probably I have understood, my lord. But your lordship.
One
then
has
where
to
will
also
section 37
think,
also
see
go?
about the future. Today I passed this order. Very well. I can
No,
can
my
very well
lord.
pass. But this order will later on be a
Yes.
precedent. Every time a person will come up. How do I take care of that? Tell me. You give
my
me a
lord.
good idea.
Until and unless the section 37 is amended by way of a
Section
legislative
37
process.
is there. This
Yes, my
can
lord.
be inserted. I can pass an order for that. But how do you take care of that loopholes when there is an office gazette? Office note, gazetted office. It is all there in the DC. You are a
my
person
lord.
who is, no. I would have understood, just for example, Mr. Joshua Seki having, who does not want to contest the election. You want to contest the election? No. For you, if it had happened, I would have definitely said yes. But for a person who is going to thinking of contesting an election, he doesn't know. Tell me. He should be more careful on that. And strangely, in the 2022 electoral rules also, your name was not there. No, it is there, not there. There
So,
also.
lordship, in 2022, as far as my document goes, my lord, I have already submitted to the authorities. So if it is not included, my lord, and that your lordship will kindly appreciate that role after the act of 2023, that role is to be revised, my lord. So, my lord, as my lord has already observed in the rules, now whether information was given to each and every individual. Now, I do not expect the higher level of the state respondents to go house to house and give information. Now, there are authorities that
No,
has been
Mr.
used.
Counsel, kindly see does 6 stipulate that? Draft rules is to be given to individuals? No.
No, my lord. Draft roll will not be given to each individual, that I know, my lord.
Secondly, 12/4 is the date on which it was published. I would have understood you coming immediately. You wake up and do it on 23/5. How do you take care of that?
My lord will kindly appreciate if my lord may kindly, may I take a lordship to paragraph 12, that I have given some explanation there.
Explanation was what? You came to know on 13/5. How do you take care of 10 days delay? Every day is very essential. How do you take care of that?
My lord, if my lord may kindly consider my submission.
I have considered.
The remedies at section 37 of the.
Understood. Section 37, this court will invoke, provided you show me something, some leeway out there. Yes, they did not. But I can't say that there was no draft electoral rules when there the document categorically says so.
But my lord, the same copy is not again before your lordship. The draft roll, publication of the draft roll, 8 March, your lordship. The copy before your lordship is the final copy, not the draft copy, my lord. That's why I was begging the lordship to, if an exception can be made, for them to produce it within 1 hour.
No, not 1 hour. Why will they wait for that?
Lordship,
My lord, on that aspect,
if
have
the
some
petitioner,
consideration, because
your lordship, if the
this is the last
petitioner,
resort for the petitioners, my
if
lord.
the petitioner pray for that section 37, then how about 38? Let them go by the 38. There's an alternative remedy. And again, your lordship here, there are thousands of citizens those who are serving like the petitioner. If the order is passed in favor of the petitioner, then from tomorrow itself, there will be a number of petition will come up and we may not be able to conduct the
Yes,
election also.
this is the only worry this court is happening.
Short span of time.
This is not a one-time.
Petitioner has already remedy. Section 38 is. When the others come forward and entered, included in them in the form of supplementary rule, petitioner was not. And when there is a remedy available for the petitioner under section 38 to go for a bill, and the passage of time is, it is not a question of the authority, it is a petitioner.
Before approaching the first authority, where's the question of appeal, my lord? May I, my lord?
No, Mr. Soso, enough. In the 2024 electoral rolls, it is also seen that there has been also a supplementary list, supplementary addition to the electoral rolls. The supplementary addition to the electoral rolls also shows that there was steps being taken by various voters for the purpose of inclusion of the name pursuant to the original electoral roll of 2024, or the draft electoral roll of 2024 being published, which therefore negates the submission made by the learned counsel for the petitioners. In the backdrop of the above, the question therefore arises that should this court pass a direction to the respondent authorities to include the names of the petitioners, taking into account that in terms with section 37 of the Act of 2023, names can be included in the electoral roll of a ward till the last date for making nominations is over. This court duly takes note of that the notification was published, notification dated 4/3/2000, duly takes note of that in all the petitions, the petitioners have categorically stated that they wanted to contest the elections. The notification dated 4/3/2024 categorically stipulates as to when the the draft publication of the electoral rolls shall be carried out. The period, semicolon, the period for lodging claims and objections, the period for disposal of the claims and objections, the period for filing appeals to respective appellate authorities, disposal of claims and objections by the appellate authority, and preparation of list of amendments after the decision of the appellate authorities, and the final publication of the electoral rolls. The same notification is not only a notification to be published in the official gazette, but the same are also endorsed to various authorities, including the recognized political parties in Nagaland. From the same notification, the dates which have been mentioned are categorically clear. And the date on which the draft electoral rolls were published is in terms with the said notification. The Form 2, which was issued, was also in terms with the said notification. The period stipulated therein for lodging the claims up till 28th of March 2024 was also in terms with the said notification. This court further takes note of that the final publication of the notification, final publication of the electoral rolls happened on 12th of April 2024. if the petitioners were diligent enough, they could have very well gotten, they could have known about the say final publication on or around in around the 12th of April 2024. However, it was only on 13th of May 2024 the petitioners have claimed that they were aware about the final publication of the electoral rules, wherein they did not find their names. Not only that, the petitioners waited for another 10 days for 10 days in case of two petitioners and 12 days in the case of the third petition to lodge claim. And immediately thereafter,
Your Lordship, 7 days, not 10 days.
one is on 23rd.
20, May
23.
20, two representations on May 20, one, May 25.
Kindly see this. Kindly see page 34. This is your complaint, NHRI, 23rd of May 2024.
Your Lordship,
Then the
page
next
32,
day,
page 32, my lord.
32.
Yes, my lord.
So they approached on 20, both.
Yes, your lord.
And approached on 20/5/2024 and 25. Two petitioners approached on 25/2024 and the third petitioner approached on 25/5/2024.
Your Lordship will see that the GB of the colony against whom my clients were about to fight the FIR have also written to the authorities taking the responsibility that it was he who has not submitted the names of the petitioner, Your Lordship.
And thereupon has approached this court. This court is of the opinion that in the instant case, the petitioners have not shown due diligence in taking appropriate steps as per the mandate of law. More so when the petitioners clearly state that they ascribe to, they are aspirants of contesting in the elections. Because under such circumstances, this court is of the opinion that this is not a fit case for exercising the jurisdiction under Article 2 to 6 of the Constitution, thereby to direct the respondent authorities to pass it for making correction of the electoral rules by insertion of the names of the petitions. Accordingly, the three petitions therefore stands
My lord,
dismissed.
if my lord is going to dismiss the case, at least reflect one of my case notes that the act cannot become subservient to the rules, my lord. Even if my
Before parting with the records, this court finds it relevant to also discuss for other effect. Before parting with the record, this court also finds it relevant to take note of the judgment of the Supreme Court in the case of Naresh Chandra Agarwal versus the Institute of Chartered Accountants of India and others, reported in 2024 SCC Online SC 114, wherein the Supreme Court observed that the rules which are framed cannot be in violation to the act.
Well, at least in respect of the petitioners, if my lord may kindly consider my
Act. Full stop. Be that as it may, full stop. The learned counsel for the petitioner therefore submitted that the rules of 2023 was ultra virus.
No, I'm not saying that, my lord, but by the interpretation of your lordship, it appears that way, if not, my lord, respectfully, my lord, if the act, section 37 is to be given effect, then at least the benefit of my clients to be able to.
I would have given Mr. Joshua, if you were not an aspirant, I would have given that. Because you are an aspirant, you cannot be. I would have otherwise, no, sorry.
No, my lord, I have no ground for appeal also because it's just a limited period, my lord. At least, my lord, may kindly.
You'll
consider
get the
that
order,
aspect.
you'll get the order, you can file it before the court.
Oh, your lordship, my lord is fully aware that I don't have that opportunity. So I beg your lordship.
Mr. Joshua, kindly
lord.
appreciate one thing, I would have done that. I would have, in the first portion, I was going to do that. But while dictating the judgment, I saw that notification 4443, very difficult, I can't do it. You have to, you are, Mr. Joshua, you are taking up the matter for today only. Your client is coming today and will go tomorrow. But the thing is, this order, if I give it, this will open a Pandora's box everywhere.
That I know, my lord, but if my lord can make it only petitioner centric.
No,
the petitioner.
that cannot be that centric. Just for example, paragraph 53 of Uma Devi has been made petitioner centric. But then also every day you file a case in the principal seat that Uma Devi paragraph 53.
My lord may also kindly consider this aspect. As a last resort, people come to court. So when no relief is received, then people will also be afraid of approaching the judiciary, my lord. No, I'm saying this, my apologies, my lord. I'm saying this because I don't have an opportunity.
Mr. Joshua, I have duly considered it. I would have granted you the relief, but can't do it now because of the fact that this will, you had that notification of court. Kindly appreciate that. You have to understand, yes, you have taken up a brief.
But at least section 37, my lord, section 37, whether one is a candidate or not, till the time of the filing of the nomination, my lord.
You see, it is a question of due diligence. Will not.
My lord, then what is the purpose of the act? If I may ask, my lord, as a matter of academic discussion.
Which one?
When the act says that till the final date of the filing of nomination, whatever the rule says or the notification says, whether the petitioner is still entitled to that benefit under the act, my lord.
You did not file an appeal, what to do?
No, my lord, because there is no opportunity. My lord is fully aware, only 3 or 4 days left. What will I do, my lord?
Next time.
I beg your lordship to kindly consider that even.
Okay, next. Yes, your matter.
Then matter petition has also become infractious, my lord.
Which one?
The petition which my lord has refused to take up today. I cannot even go for appeal. There is no time limit now. But the time limit is against me, my lord.
Is he also an aspirant?
Incidentally, my lord. Oh, my lord, here is a case where.
You do one thing.
This is not a trial.
No, it's okay. You do one thing. Let this matter be listed in before the other bench. You may get a better order.
No, my lord. With this, if my lord is going to transfer the other 2 matters which my lord has now almost come to a conclusion, then I would take chance. But how can this case be again taken up separately before the other bench, coordinate bench? I feel it's very unfair upon the petitioners because not getting a benefit under section 37, just because the rule and notification says so, whether the provision of the section 37 of the act, the parent act, whether that can become subservient to the rules and the notification issued thereupon.
Mr. Seki, it is because I am sitting in the Kohima bench, I am allowing you to make so much of submissions.
I understand. My
normally, if it was in the principal seat, if the matter would have now finished, you have to say anything, go and file in the division.
Yes, my lord. Bless your lordship.
What do you want to do with the other matter? 43.
What notice will be sent now, my lord? By the time my lord is sitting here, the period for filing the nomination will be over.
You filed it on 3. Here also 12-4. 12-4. How do you take care of it? This is on 29-5. And you've written to the deputy commissioner. When is the next date here?
Then my lord include a particular observation which my lord has said that if the petitioners were not a candidate, which my lord has expressed in an open court, I'd like to beg the lordship to kindly include that in the sentence in the order. If the petitioners were not a candidate.
Yes, that I put it. I made it very clear. Petitioners were, therefore they were more, should have been more diligent. No, we can issue notice here. Here also you say that he's a party. You still have time till 11th. We issue notice making it returnable on 7th.
But this also covered as returns.
But then also something has to be done formality. Issue notice making it returnable on 7. 7 is Thursday.
Friday.
7/6/2024. Mr. A.M.D. Imsong, the Learned Counsel, Additional Advocate General, appears on behalf of the respondent number 1 to 4. Steps be taken as respondent numbers 1 to 4 are duly represented. Extra copies of the petition be served upon them. On the returnable date, the matter on the returnable date, who is the ERO? This is the ERO.
The ADC.
We have not made him a party also.
The district election officer is the DC.
Before the returnable date, the respondent number 3 shall file an affidavit.
The respondent number 4 is.
Why 4? Why 4? 4 has no business out there.
4 is the ADC model.
You see, he's the returning officer.
4 is the.
Let it be filed by DC. Returning number 3 shall file an affidavit as to whether the draft rules were published, and if so, when. In addition to that, the said respondent shall also apprise this court as to what steps have been taken pursuant to the representation submitted by the petitioner on 29/5/2024. File a short affidavit.
For hearing, item number 23.
Here, the thing is, Lordship, my case is well covered by the decision passed by the division bench in April 35 of 2022, Lordship. That was pronounced on 6th of February 2024, Lordship. However, Lordship, against that judgment, the state has already, I'm told, taken steps for preferring an assembly before the.
Oh, last 3 months when I came back, I came in the month of February last week.
Lordship.
The same submission was being made by the state.
Yes, Lordship.
Are they still preparing? Have you filed? In this case, have you filed the appeal before the Supreme Court? It is the same state of affairs. They can't say that we are filing it all. When the order is clear to that effect,
My lord.
then it is okay. Matter ends. So you have not filed the appeal. You are only thinking, contemplating, which is being last 3 months has been going on. That's the order passed by Justice Robin Fukon and,
Yes, my lord.
and I think
Justice Puti Habong.
yeah. So there, I think the judgment which I along with Justice Shyam have delivered have also been held to be for inquiry.
My lord.
Lordship, let it be passed over for the Lordship. Thanks.
It has been served counsel appearing on behalf of the petitioner that the instant petition is covered by the judgment of the division bench in the case of, just give it to me.
State of Nagaland
By the
versus
judgment
Hong
and
Kong.
the judgment and order dated. Judgment and order dated
to 2024.
to
6/2/2024.
6/2/2024. And passed in writ appeal number
35 of 2022.
2022. However, the counsel appearing on behalf of the respondents submits that the state is taking steps for filing an SLP against that. And on account of the summer recess, the matter is likely to be taken up by the Supreme Court immediately after reopening. Taking into account the above, this is the matter again on 22nd of July 2024.
My lord.
By that time, it will get dismissed.
Deeply oppressed.
For hearing, item number 24.
Next option. Lordship, what may be grant precious not to pass over the matter. 2 weeks, Lordship.
Why?
Lordship,
What is this matter about?
Regarding a seniority, Lordship. Seniority of forest guard. Forest rangers.
Forest guards.
Forest ranger.
Matter pertaining to 2022. So many times adjournments. Readings are complete in the year 2022. Then why do you need it after 2 weeks? Give me a good reason, valid reason. Why after 2022?
Lordship,
Are you enjoying an interim order?
no, Lordship.
There is an interim order.
Yes,
There is some order passed, the interim order passed earlier shall continue till the next returnable date. Who is that? What interim order? Till the returnable, no promotion order basing on the impugned finance should be issued. Is the interim order? Or it has been vacated? You are not interested. Not interested. Senior is having a difficulty today. Why after 2 weeks? 2 more weeks.
Lordship, on the concern of the additional AG, he said they shouldn't be present next week.
Who?
Additional AG.
Then how is it relevant?
So
The
she has
state is
requested
not
for 2
represented
weeks.
very well. You have a very good path. There's no problem. The impediments or the hurdles or the obstacles are no longer there. So next week.
Next week, Lordship.
What? Who? Who is appearing? You have 3-4 additional AGs. Ask any additional AG to appear. If you want them tag out there. Otherwise, you are there. This week. We have it on Friday. List the matter on Friday.
For hearing, item number 25.
Yeah, please, Lordship. Lordship, I'd like to mention on behalf of S. Mayor, Lordship. This matter will come after 2 weeks, Lordship.
Is it stay? Is it stay?
No, Lordship. The stay is still the disposal of the petition. Stay has been granted till the disposal of the petition.
Accordingly, it is provided that the impugn orders when so, appointment shall stay till the disposal of the petition. Means there's a stay.
Yes, Lordship.
So you are not interested. What is the matter about?
Lordship, this is for regularization and a grant of minimum skill pay.
Huh?
Regularization and grant of skill pay.
You don't have scale.
Yes, Lordship.
No, you don't know this. This is appointing somebody else. For initial appointment demand as per the direction of the Supreme Court in Jagjit Singh. I fixed that matter, the Jagjit Singh matter on a particular date, na? Today there was one matter. When did I fix it? To file an affidavit? Hey, that was one matter, no? She was appearing. With it. There was one lady appearing, no? What was his name?
That's item number
15. 15. Where I have asked them, they say that there is a committee form, na?
Yes, Lordship.
On 2016 to 2024. I fixed it on giving them 3 weeks time. Jagjit Singh or kotha je likhiche etu ketia 17. Okay, we have it on 17 then, because this will have the relevance with that. Taking into account the stand of the state, that a committee has been formed by the notification dated 16/2/2024. To address issues which are subject matter of consideration before this court. in view of the judgment of the Supreme Court in the case of State of Punjab versus Jagjit Singh, reported in so and so. This court fixes the instant matter on 1/7/2024.
For hearing, item number 26.
Yes, what is this?
The matter states to not the field of civil contract.
Contractual bills.
Yes.
What do they say? Why you have not paid?
We have category stated.
Huh?
In fact, the money has been, the pending bills has been paid to the
Paid?
already paid.
Then?
And moreover, Lordship, I have raised a preliminary objection.
Wait. Let us see your stand. What do you say? There is no liability or bill pending for the two works orders, so and so and so and so. That the payment against the work order issued amounting so and so was debited to the account of so and so as full and final as so and so. Furthermore, another work order dated so and so, amounting to this amount was debited in the account of so and so as full and final payment is 2,37,000. Therefore, the claim that the pending bill of rupees so and so is totally misconceived. Moreover, there is no breach. So now, in view of their categorical stand, how is your repetition maintainable? You can very well file a civil suit as regards the remaining amount. When they say, because you see, if there is a denial, this court can't do anything. And this court can at best pass an order asking them to consider. Now, I can't ask them to consider because they have already come up and said that look here, they are not entitled to a single penny because all payments have been made. So I did give you the leave to file a civil suit now.
Kindly appreciate that.
Yes.
What's inclusive document, it shows that an amount of rupees 12 lakhs, 99,000 was released to the petitioner. They are admitting that fact.
Huh?
They have admitted the fact that an amount of rupees 12 lakhs,
Ah.
99,000 has been released.
Yes.
We can come to the affidavit reply.
Now they say that the 15 lakhs, full payment of 15 lakhs has been after minor deductions.
Yes, Lord.
15 lakhs, then?
15 lakhs.
Yes.
But there's no report to show that 15 lakhs has been released, Lord. There's only a report.
Payment of so and so, you say, was debited to the account of Watson Committee?
Yes, Lord.
You are who? Watson Committee?
No, Lord. They are not a Watson committee. In fact, they are a contractor.
They are?
They say, they are before the committee court saying that they are the contractor who has executed. However, the work that was issued was in the name of the chairman Watson committee.
Oh.
So
you say that you have paid it to Watson?
Lord.
And he says he was a subcontractor of Watson. So you have to take it up with Watson.
Lordship.
Watson was also included as a party here, Lordship.
So
And
therefore-
there was also a resolution, Lordship, which have been closed in this petition.
No, therefore,
Yes.
I will give you the leave for filing a civil suit against Watson because Watson is not what do you call, it's not a state. Is it a state? Your dispute now, in view of this affidavit, categorically is between you and Watson.
Yes, Lordship. And Watson has been constituted, Lordship, by the Department of PHEB, Lordship. Very much, Lordship, state.
Understood. Whatever may be, they granted the contract to Watson.
Lordship, yes, Lord.
Watson gave you a subcontract.
Lordship, a decision was taken by the representative, the representative of the department was also there, Lordship, at a meeting, as well as Watson and the contractor, Lordship. And this is not only one contract, Lordship. 3 different works were discussed, Lordship. And the contract was awarded to 3 different contractors, Lordship, by the resolution itself. And in the presence of even the department, Lordship. Watson was also very much there in the meeting, Lordship.
But how do you extend the writ against them?
However, the fact
This court can, whatever this court can pass, can the court, as of now, when they say we have paid it to Watson, can this court direct, you again pay it to the petitioner?
But there is no report to show that it was released to Watson.
They say on affidavit.
Lordship, but there's no check. Lordship, I have enclosed a check which shows that an amount of rupees 12 lakhs was only released. Lordship. And they have also made statement that after deducting minor deductions, after making minor deductions, 2 lakhs rupees cannot be a minor deduction.
What 2 lakhs? 16 lakh 5,000 is the total amount, of which 15 lakhs 88,000 is that. This is not 2 lakhs, it is only 17,000.
Wait by the report. Because I have enclosed, if your lordship may tell me for a moment, lordship, affidavit reply, page 10, page 10. What's why I agree the amount was released in the account of Watson, lordship. I agree with that. Page 10, my affidavit reply.
Affidavit reply, okay. Then?
And it should be the last page.
Para 4? Well, let's see what you say about para 4 in your reply. With regard to answer, denies the statements and memorandum, the deponent further denies that there is no liability or pending bill for the 2 work orders, so and so and so and so. The state respondent in the affidavit have stated that so and so amount of demand only in respect to the first work order and demand. And so and so have issued demand. To say that the amount is already credited to us, and despite an amount of so and so was credited in the department's account, which was to the penny in the beneficiary without any deduction, an amount of which only was released in paper. So you got 12 lakhs out of 15 lakhs.
Yes, Lord.
Who issued the check of this 12 lakhs to you?
Executive engineer. Mainly issued by the PhD.
This is this 12 lakhs only.
That's the sufficient.
No, this is only 12 lakhs.
Yes, Lord. And they have stated in the affidavit that 15 lakhs was released. Whereas I was paid only 12 lakhs. And this was paid issued by the chairman, Watson Committee.
But why the Watson Committee is not coming before the court if they have not received it? Show me your agreement with Watson.
Watson has been included as respondent before.
Show me your agreement with Watson. Because the direction was given to the contract was given to the Watson.
Yes. There's a meeting distribution.
Then where page?
Page 19. Type copy.
The House unanimously decided and agreed to distribute the works to 3 parties, so and so for department. And therefore, the village council has requested the department to kindly work orders to the respective council area. Then where is the work order?
Page 13.
Huh?
Page 13.
1-3.
1-3.
No, 1-3 is to Watson.
Yes, Lord.
I'm not on that, to you.
There's no formal work
Then
that has been issued by the Watson.
how do I help you? Your problem lies with your Watson. And the thing is, you have, they say on oath that they have debited that amount, 15 lakhs. If the amount has not been received, because the work is only given to Watson.
Lordship, but in fact, the work has been allotted to the chairman. Not to the president.
Watson may have a case.
In this present form, Lordship.
But did you pay the 15 lakhs? It's on oath you are stating. We do one thing. Get your instructions by Friday. I'm making a specific note out here that he says that 12 lakhs 99,000 and you say 15 lakhs. To kindly verify and inform this court. I think better off, no? Good stuff. The instant writ petition has been filed for recovery of an amount of rupees 5,45,541. Along with interest. The basis on which the claim is being made is that the respondent number 4 herein was issued a work order for construction of a deep tube well with IRP bracket 1 numbers, and the contract value was rupees 16 lakhs 5,000 055. It has been mentioned herein that the respondent number 3 have released rupees 12 lakhs 99,902. However, an amount of rupees 3 lakhs 5,153 was pending. In addition to that, the petitioners also claim that as regards construction of a 10,000 liter RCC reserve tank, an amount of rupees 2,40,388 is payable to the petitioners. On the other hand, it is the specific stand of the respondents state in their affidavit in opposition that out of the amount of rupees 16 lakhs 5,055, an amount of rupees 15 lakhs 88,812 was released to Watson Committee Teso Penu. In addition to that, as regards the amount of rupees 2,40,387.58, another amount of rupees 2,37,498 have been issued, have already been debited to the account of Watson Committee Tesopenu after making minor deductions. This court also take notes of the reply which has been filed, wherein it has been mentioned that the respondent number 4 have only been paid an amount of rupees 12 lakhs 99,902 by way of a check, and no further amount has been paid. Under such circumstances, this court fixes the matter again on this Friday, on which day Mr. V. Jimomi shall obtain instruction as to how the said amount of rupees 15 lakhs 58,812 was paid to Watson Committee Tesopenu, and a further amount of rupees 2,37,498 to the same party. The said details shall be brought on record by filing a very short affidavit.
In fact, in my next year, page 9.
Your affidavit. Page.
The amount is in
Where?
page 9.
And the other is? The other amount?
Other amount is at page
Page 12. Oh, this one. Oh, what remains from this? We can't entertain any further. Don't write anything. We dismiss the petition. Okay. Dismiss.
Claim from the Watson lordship.
You withdraw with liberty. I think better off. Like. Heard Mr. So-and-so, heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner, and Mr. V. Jimomi, the learned counsel appearing on behalf of the respondent. The instant writ petition has been filed claiming an amount of rupees 5,45,541 from the respondents. It is relevant to take note of that the respondent, number 4, was issued 2 work orders. One work order was in respect to construction of a deep tube well with IRP bracket 1 number at Tesopenu village, wherein the total estimated cost was rupees 16,05,055. The second work order was of the same date for construction of 10,000 liter RCC reservoir tank number 1 at Tesipano village of a value of rupees 2,40,388. It has been alleged by the petitioner herein that the petitioner had in fact was subcontracted by the respondent number 4 to carry out the said work. And as only some payment have been made and not the entire, the petitioner therefore has filed the instant writ petition challenging, seeking direction for the payment of rupees 5,45,541. On the other hand, this court duly takes note of the affidavit in opposition filed by the respondent number 1, 2, and 3, wherein it has been stated at paragraph number 3 that out of the amount of rupees 16,05,055, an amount of rupees 15,88,812 have been duly paid. And out of the amount of rupees 2,40,387.58, an amount of rupees 2,37,498 have been duly paid. All these payments were made to the respondent number 4, to whom the contract was awarded. This court also have taken note of the enclosures to the said affidavit, which categorically shows that the said amounts were duly paid to the counsels, to the respondent number 4 by way of bank transfer. Bank transfer, no? Bank transfer. Under such circumstances, in the opinion of this court, the grievance of the petitioner can at best be a grievance against the respondent number 4 and not against the state authorities. Accordingly, in that view of the matter, the instant writ petition, in that view of the matter, the remedy of the petitioner would be qua the respondent number 4 and not the state respondents. Accordingly, this court finds no merit in the instant petition, for which the instant petition stands dismissed. Be that as it may, the dismissal of the instant petition shall not preclude the petitioner to approach the civil courts for seeking relief against the respondent number 4, if so prescribed under law, if so permissible under law. Yes, just one more item. Yes, Mr. MD.
Item
You've
numbers
been waiting from
41
the
and
morning.
42.
The way old matter. Well, what is the matter about? We do it, can we take it up tomorrow?
Yes, no.
Because today it's already 4:45.
This is some matter.
So
But he
therefore,
was arrested by the police. They are saying that
okay, we do one thing, tomorrow we take it up. First thing, whatever matters are there, if some motion is there, it's okay. Then first hearing, we take it up this way. Or we can take it up at 2. Which one do you want?
what are the, let it be fixed tomorrow.
2 p.m. Then we immediately take up this at 2. You will know. Fantastic. Taking, let this matter be listed tomorrow at 2 p.m.
What? What?